Welcome to Looking at Legal Stuff. Today we have day 3 and 4 of an evidentiary hearing in the divorce of a couple where mom claims she left the relationship because she could no longer tolerate being in a marriage to a man who was so angry and controlling. She says he never helped her with their child during the marriage, and she wasn't allowed to go to work unless she took their son with her, as his father refused to watch him. She says he even demanded that she earn a minimum of $800 a month, despite the fact that he refused to help her with daycare. Mom says that not only did he drink and use drugs a lot, but he also drove while drunk because he says he doesn't care, and he even bragged about it on tape. She says he didn't even have an actual driver's license until a few months ago. What does Dad have to say about these and Mom's many other accusations? Let's find out. Make sure to watch Mom's explosive testimony from day 1 of this case, as well as the testimony of Dad and his family members in day 2 that I'll link for you in the description box down below.
Session, the Honorable Judge David Wolf presiding. All ye have in business before this court draw nigh and you shall be heard. God bless the United States, this state, and this court.
All right. I believe yesterday when we adjourned that Ms. Grammon was on the witness stand. So Ms. Grammon, if you'll come back, please. Holly, you may examine your client.
I have no further questions for her. I'm good. I don't know if there's any.
Do you have questions for her, Ms. Hendrickson?
No, I don't.
Then you can step down.
Thank you.
I would call Patricia Grammon her mother.
Patricia Grammon. I'm sorry, what's your name?
Patricia Grammon. Patricia Grammon, her mother. Madam Clerk, do we have the exhibit of the church basement? It's got to be 10 or 11. Yes.
Come up, please, ma'am. Raise your right hand. Let the clerk place you under oath. Holly?
Yes, sir. Ms. Grammon, state your full name for the court, please.
Patricia Ann Ray.
So I'm calling you, I'm sorry, it's
That's
not Grammon.
okay.
It's Patricia Ann Ray, R-A-E?
No, R-H-E-A.
R-A-G-A, all right. And you're the mother of Tony Grammon, correct?
Yes.
You had an opportunity to supervise some of these visits, have you not?
Yes.
How many visits would you say that you supervised?
8 to 10.
And these visitations that you supervised were because the forge had a conflict with time frame, correct?
Yes.
And that was was that by agreement of the parties?
Yes, and I agreed to help out.
Okay. I may approach.
You may.
We'll show you a picture that we introduced as evidence already. I want to ask you if you recognize that picture.
Yes.
Now, what is that picture?
It's a picture of Brian and Pearson in the commons area where we would meet, and Brian with the gun in his back of his pants.
Did you take that picture?
I did.
Did that picture cause you concern?
Yes.
What concern did you have when this was going on?
Well, I was worried that, number one, for Pearson, to possibly be hurt by it or grab it, or I mean, I don't know a whole lot about how easily a gun can go off. Also, I kind of felt intimidated by it. Why is he doing that to where I can see it?
Were there anybody else in the room with you and Mr. Mr.
No.
Grammon at that point?
No, just us. It was always just us.
And did he know that it was just you coming to the visitation to supervise?
Yes, that's how it always is.
How did you feel about somebody needing a gun to protect you from them?
Ridiculous.
Did you have opportunity to see other weapons on Mr. Grammon during these visitations?
I did on
Explain
the,
that to the court, please.
yes. I also, and he had a knife on his, I guess it was on his waist because it fell off as he was walking past me, and it fell and hit the floor and opened up.
How big a knife was it?
Well, once it opened up, I don't know, maybe like that.
Do you feel like Mr. Grammon did that and had the gun there to intimidate you?
Possibly.
Did you see or hear anything in regards to the interaction between Brian Grammon and Pearson that, as a supervisor, caused you any alarm or set you back any?
Yes, I would watch Pearson to see how he reacts with his dad. On one occasion, Brian asked Pearson in an angry voice, "What did you call me?" Just asked him again, "What did you call me?" I don't know if he thought Pearson called him Brian, because I actually didn't hear what Pearson said. And of
What was
course,
Pearson's reaction to Mr. Grammon's words then?
he just looked at it like this, just kind of looked stunned and not knowing what to say. Looked maybe a little scared, just not knowing what am I supposed to say? He's 2 years old.
Objection to speculation.
Well, Judge, you
And it
testified
would
what you
seem to be
witnessed.
speculation.
I'm sorry.
It would appear to be speculation. You have some way that it wouldn't be?
I thought what you testified to is what you actually observed on Pearson's face when Mr. Grammon said these words to her. It's what you actually saw and observed from her vision.
She can testify about what she observed, but interpreting what she observed is the problem. She can testify as to the expressions and reaction, but again, being able to testify and interpret that as meaning certain things would be speculation on her part. Anything else, Ms. Hendrickson?
So just to be clear, as far as you witnessed his reaction, can you describe what you witnessed to the court?
He looked stunned and speechless.
All right. Did you have opportunity to hear Brian Grammon try to get additional information out of Pearson?
Yes,
Explain that to the court.
yes, a few times. There was times when he asked Pearson, where did your mother take you today? Did she take you somewhere? And he was like interrogating him to ask him, what has your mother done today? Did she take you to work with her? Did she go somewhere? Another time he said, did she go somewhere this weekend? Did she leave you with somebody? How did that make you feel? And Pearson is, again, speechless. So he did that 2 to 3 times when he would come in there, just trying to get information from Pearson about Tony.
Did you ever talk to Mr. Grammon yourself about the gun or the knife at all?
Yes.
Did you bring that up? What did you say to him?
Initially, the first time he brought the gun, I asked him, why do you feel the need to bring a gun in here and into a church and to visitation? He said it was his right and it was safe. Pearson couldn't get it. And so he brings it again to another visit. And so finally I took a picture because I was put out with it and I just didn't know what else to do, so.
Fair enough. That's all I have.
Hendrickson?
Good morning, Mrs. Grammon. I represent
Brian Brennan. Isn't it true that there were times when you would tell Mr. Brennan that you were available on the days that he requested for a visit, but your daughter refused those visits?
No, that is not true.
So you never told Brian, oh, I was available that day. I don't know what happened. You never did that,
No, I did not say that.
okay? Now, the gun situation, after you took the picture and gave it to your daughter, isn't it true that you had never seen him bring a gun anymore?
That is true. He did not bring it anymore.
How about a knife? Have you seen him bring a knife after that incident?
No, he did not.
Okay. Do you recall when Mr. Graham went to your house to try to see Pearson and then the police got involved? Do you
Yes.
recall that? Were you there?
Yes.
Do you recall your husband brandishing his own gun to Brian?
No, I did not see that.
You did not see that, okay. Isn't it true that y'all refused Mr. Graham to see Pearson that time, even though you had a police officer there?
Right, we did refuse.
Okay. What was the reason for the refusal?
Brian had wanted to see him, but Tony and we were very fearful of him at this time.
Did he have a gun at the time?
I don't know. He always,
Did you see him when he was trying to see Pearson at that time, that moment?
did I see Brian?
Yes.
I saw him out the window.
Did
Come
you
out.
see him carrying a gun at the time?
I couldn't see. I was far
Was he
away.
threatening you all that he's gonna inflict injury to anybody? Was he verbally threatening anybody? Or was he just trying to have a glimpse of Pearson?
I could not hear him. I was in the house.
Okay. At any point in time when they were still living together, isn't it true that Brian told you and your husband of your daughter's physical abuse upon him? You remember that?
I remember Brian telling me one time that Tony hit him.
Okay. And so, do you feel that's right to do to your husband?
To hit my husband?
To hit anybody? Is it?
If we're objecting to speculation, Judge, I'll object to
I'm
speculation
asking for her
as well.
opinion, Your Honor.
When Mr. Holly is making an
Sorry.
objection, I know you would love to be able to respond as quickly as possible, but wait for him to finish so that I can understand what he's objecting to. He's objecting to speculation on, she would have to speculate in her answer, is that correct?
Yes, sir.
All right, his objection is that the witness would have to speculate to answer the question. Now you may respond.
I'm simply asking what the witness thinks about the rightness or the wrongness of someone physically assaulting another person, such as in this situation.
Okay. Overruled. Repeat your question, please.
Mrs. Graham, I'm just simply asking, is it correct or right of your daughter to physically abuse her husband?
Well, I don't think she physically abused her husband, but I don't think it's right to hit anybody.
So hitting is not physical abuse to you?
I don't object to that being a little argumentative.
Today
She's,
is argumentative.
I'm moving on. Have you seen your daughter discipline Pearson?
Yes,
How does she discipline Pearson?
depends on what he did.
Okay.
Can you be more specific?
Has she used foul language on Pearson?
No,
Has she screamed at Pearson?
no.
Okay, so you just testified that you've seen her discipline. Just if you can just tell me what type of discipline have you seen from your daughter?
She does timeout at this point when he misbehaves. She will talk to him. I guess you could say, fuss at him, you raise your voice a little, you don't do that,
Okay.
or,
Is there anything else that you haven't seen her grab Pearson from just one arm and lift him up
no,
when she's frustrated?
no.
Isn't it true that you and your daughter had a cleaning job at Mr. Grunn's business place in, I want to say Nashville, correct?
Yes,
And that office had exotic animals in there, such as snakes and all those things.
yes,
And you all had Pearson with you.
yes.
How old would Pearson be at the time?
From the time that
You started
we
cleaning there.
started.
Mhm.
How old? I'm guessing because I know he was really little, so a year?
So, okay, was he walking already, or did he have to
No,
be in the?
No, was not walking when we started.
Okay, and then he eventually started walking, is that right?
Yes.
Okay, so who would be keeping an eye on him when y'all are cleaning the office?
I usually cleaned that office.
Okay, but there were times when your daughter was with you and Pearson, correct?
But the office you're talking about is separate from the whole building. It's a
Okay.
door. It's just that's the owner's office. So I usually cleaned it because I'm a little particular since that
Okay.
is his office.
Yeah, I'm particular too. Well, so, but there were times when, so are you saying that that's a big building and you're specifically in the office? So what's the other part of the building?
It's full of instruments.
Okay, and so where would your daughter and Pearson be?
They could be on the first floor, which is the showroom,
Okay.
which has a lot of instruments.
Would
That's all they
would
say.
Pearson be with her every time she would be cleaning the place?
Would he be with her the whole
I'm just
time?
trying to figure out where Pearson would be when y'all are there cleaning, whether you're in the office or if she's in another area. Where is the Pearson be?
Well, we used to take a pack and play, a play pen that you can
Okay.
fold up. He was in there a lot.
Okay. And what kind of chemicals did you use to clean the place?
Mostly window cleaner, glass cleaner.
Okay, so Pearson would be exposed to all these things that you were using.
No, we kept him away from when we sprayed or wiped anything down.
So where would be the pack and play be?
Kind of to the middle of the room
Okay.
because we didn't want it near, they've got expensive instruments, so we'd usually, and it had wheels, so if we walked over to this end of the room, we'd wheel him with us.
Okay, so wherever you're at, he's there and you're using all these chemicals, correct?
Just glass cleaner on the glass.
What else do you use for cleaning? Seems to me like it's a pretty big, undertaking. Is that all you use to clean the building? Just the window cleaner?
A lot of vacuuming,
Okay.
mostly vacuuming, taking out the trash.
So you're saying that you're only using a window cleaner to clean that office?
The floor and then mopping the floor.
What do you use for mopping the floor?
I usually use like some kind of floor cleaner, like Mr. Clean, pour it in the container on the mop. It goes inside of there, you close it, and it squirts right at the floor, like a Bona mop. I don't know if you know what that is.
I use
So-
Bona.
Okay, so that's pretty much what I spray the floors with that, so there's not a bucket for him to get into. perfumes.
Well, isn't it true that when Mr. Graham found out about this, that he stopped it, correct?
Stopped what?
Your daughter bringing Pearson to that place because he just didn't think it was safe for him to be around all these exotic animals and cleaning materials that are just not, good for a child to be exposed to.
No, that is not true.
Did you hear Brian tell your daughter?
No,
So you won't have personal knowledge of it, right?
he told me.
Okay, what did he tell you?
He told me she's not cleaning with me anymore because he was mad at me.
Because what now?
He got mad at me
For what?
because he read a text that I sent to Tony
Okay.
because she was, they'd been fighting. She was very upset. I knew he would read the text.
What is in the text, do you recall?
I told her that she would be better off without him.
Okay.
So he said she could not clean with me anymore.
Okay. But it's true, partially at least, that he had requested for Tony and Pearson not to go in that specific location.
There's no
No.
object at this point. This is ask and answer. She plainly said no to this question already.
Exactly, what is the point of all this?
Well, just subjecting the child, mother and grandma and mother, subjecting the child to this situation that should not be.
And that
But I
is,
will move on, Your Honor.
that is cleaning this building?
With exotic animals and using chemicals?
Let me ask this question, whose building is this?
Mr. George Gruen, it's Gruen Guitars,
Okay,
in
and where is it
Nashville.
located?
8th Avenue North.
In Nashville?
Yes.
Okay, and what kind of exotic animals exactly are we talking about?
Snakes. He likes snakes.
You let them run around loose
No,
in the
sir.
building?
They're in,
Uh,
is it okay?
What do they call it? Not aquariums, but some sort of a glass enclosed case.
Right.
What kind of
many
snakes are they? Are they-
I don't really know. They're big. A lot of them are big, and
How
some
many
of-
snakes does he have?
Probably a dozen.
You ever see the movie Raiders of the Lost Ark?
Yes.
The lion snakes, it had to be snakes. Some people don't like snakes very much. I'm not fond of them, although I've handled quite a few in my life, but I will say this, is there any reason your grandson has to go with you all to clean house, or she doesn't clean with you anymore, is that correct?
That is correct.
All right, so whatever happened before she stopped cleaning.
Yes.
All right, and was there ever an incident where any of those exotic animals were loose?
Never. They're always in a cage with a lid on them, and they clamp down so the snakes
So
cannot.
that's the
get out.
snakes. What else, what other kind of animals are
A
there?
turtle. And
Is
that's
it a
also in an
dangerous turtle?
enclosure. No, sir.
Snapping turtle, for example, anything like that?
No, because I have handled it before,
Oh.
and it's not.
What else?
A cat.
What kind of cat?
It's a regular house cat.
All right, and those are the exotic animals that we're talking about. I don't, Ms. Hendrickson, I know you said you were going to move on, but I had those questions in my mind anyway, since there was an objection to it, but apparently this is something that happened in the past, and
But
I
it
don't
still
particularly.
shows her decision-making abilities, but I'll move on. If I can just look at my notes real quick. Mrs. Grannon, in the event that Judge Wolf continues to order the supervised visitation, would you be agreeable to supervising it at Brian's home?
Where, I'm sorry,
At Mr. Grannon's home?
okay.
No.
Okay. What's your concern about that? Is it just inconvenient for you to far, or?
I guess I don't feel comfortable.
Okay. Were you aware that he has been attending, he did attend anger management classes, attended parenting classes? Are you aware of that?
I am aware of that.
Okay. and he's gotten his driver's license. You aware of that?
Brian told
Just
me.
yes or no, ma'am.
Brian
Are
told
you
me that he
aware?
did
Okay.
get, Brian told me he got his driver's license after
Okay.
we had asked him for years to please get your license.
And he did.
And he would not do it. He
Ma'am,
said
I'm
he
just
did not
asking
want
if
to
you
do
know if he has a driver's license.
it. Yeah.
Are you aware that he has attended a CPR class for children?
I think he told me that he did that.
Okay. You aware that he attended some courses on gun safety and all those things?
He told me he did.
Okay. Were you told about the situation with his apartment where he's not permitted to bring alcohol or drugs or anything like that?
Repeat that?
Are you aware that in his apartment lease, he is not permitted, or at least it's forbidden, to have alcohol or drugs in the whole community? Are you aware of that?
Judge, I would object to the relevance, kind of with this line of question. I let a couple of questions go, but I don't know what this has to do with any
I think
relevance
Ms.
as
Henderson was
to.
trying to establish that there have been changes in Mr. Grammon's life that he has affected, that she's questioning whether or not she would feel comfortable going to his house to supervise visitation, and asking her if she's aware of these changes he made. Am I correct?
Yes.
That's the purpose of your question. Overrule the objection.
You recall the question? You want me to read?
Read it.
I think I was asking you whether the apartment lease that Mr. Graham signed, if you're aware that the lease prohibits any tenant from bringing in alcohol or any illegal drugs, and that the management has authority whenever they want to go into the house and inspect. Are you aware of that?
Yes, I also rented to Mr. Grammon, and that was in our lease too, no drugs or alcohol. But it did not stop him from doing that. I found pot, drinking, he did not
Did you call
care.
the police on him when you found pot?
No,
Isn't it true that at some point during the visits, you had told Mr. Graham that you were okay to supervise at his house? So that it would be more comfortable for the child?
repeat that?
Isn't it true that in one of your in one of the supervised visits where you were supervising, that you told Mr. Graham that you would be agreeable to supervising at his house, so there'll be more comfortable and more natural environment for Pearson?
I remember him asking that, but I never agreed to that. I remember him saying it would be much better where he could see his own room and be more,
Yeah.
just more easier for him, but I never agreed that I thought that was a good idea or that I would go there and do that.
You want if I can make confirm with my point? Okay. Mrs. Grammett, you just testified that it'd be better if he's in his room. Would you be agreeable if he does it in your home? With your, whoever will be the supervisor? If the judge continues to supervise visits?
In my home,
Yes, ma'am. With orders in place about restricting of no guns, no drugs, no alcohol, the Judge Wolf will surely, and I'm taking a step forward here, if in the event that the supervised visits will continue, Judge Wolf will probably put in some restrictions there to safeguard the supervised visits. Would you be agreeable to that?
I think there has been too much that has gone on in my house that my husband and I have witnessed of Brian screaming, cursing, not only my daughter, in front of her child. That, no, it's just not, it's not a good idea. There's too,
Yeah, if there's an order that says Brian can't do this, this and that, and y'all let him go if it happens, and, you know, the lawyer can file a contempt for violation of the orders, you are going to have some type of an order. If the judge wants to do that, do it that way, you would still not be comfortable.
not in my home.
That's fair. I have no further questions.
Charlie?
Testified you didn't feel comfortable with Mr. Grammond. What's the biggest reason you don't feel comfortable with Brian Grammond?
Brian can be very vindictive. I've seen his explosive behavior, not only to me, to my daughter, and in front of Pearson. I've seen him scream, rant, and rave in my home. They lived with us for a few months.
When he gets in that mode, can you control Mr. Grammond?
No,
Or your testimony would be he would be out of control at that point, you wouldn't be able to do anything?
that's right.
And Mr. Grammond, I think according to your testimony, you violated some rules you had before when he lived with you, or was over at your house. What rules were those?
My husband told him that he could not have any pot, which he has told me he has to have every day, cannot go without a day without smoking. We told him it could not be brought on our property. No alcohol. We don't allow alcohol at our house. That eventually was found. So he did what he wanted to do. You can ask him or tell him these are the rules. But he
Did
will.
you go back to Mr. Grammond then and say, hey, we found alcohol and drugs? You need to get him out of the house?
No. No, well, I'm not to my knowledge.
That's all I have.
Follow up, Your Honor. Have you seen Brian physically abuse or put his hands on Pearson at any point in time?
No.
If I represent to you that Mr. Grammond has not had any illegal drugs, which is marijuana, since the separation, that would have been 6 months from that time, and he is willing to do whatever drug screen the judge orders, does that kind of help alleviate some of your concerns?
No.
That's all, Your Honor.
Mr. Holly?
You ever heard Mr. Grammond threaten Pearson?
I have not heard him threaten him, but during the visitation, he has said a couple of things, asking Pearson, do you have a dirty diaper? And you better not be lying to me. Telling a 2-year-old, you better not be lying to me, because Pearson will always tell you no. He doesn't want his diaper changed.
So he ever told you to do anything you felt like was inappropriate to Pearson?
Yes.
Tell the court.
One day I was at their house and Pearson pulled my glasses off like this. He likes to play with them. And I don't mind it, but Brian did, and he told me to smack the shit out of Pearson.
Nothing further.
Nothing further, Your Honor.
Thank you, ma'am. Let me ask this question. When the visitations occur at the Church of Christ there in Alexandria, who all is present for that?
I am the sole person supervising, and then Brian and Pearson.
Okay. So in the room, for example, where that photograph was taken, the only people in that room are you and Mr. Grammond and the child, correct?
Yes.
Are there any other people at the church?
Working in the church? No, it's closed during
Is
the
it
week.
completely vacant except for you three?
Yes, unless somebody would, there was a man that mowed the yard
And
occasionally.
my question is that obviously the supervision is for the protection of the child according to what they agreed to. And I'm just trying to determine how much supervision there is and how much, there are other people around in the event of some incident. I know this gun incident that disturbed you, but all right, that's all I had to question. Thank you. You can step down. Mr. Holly, you may call your next witness.
I have a moment. That's our proof, Judge, other than closing argument a little bit.
Ms. Hendrickson, do you have any other witnesses you wish to offer? Any other proof?
I don't have anything else, Your Honor.
All right, I'll hear you in argument. Hendrickson, you're the moving party, so you'll go first.
Your Honor, when I was researching a separate issue for one of my other cases, I came upon Schaffner v. Schaffner. It's a Court of Appeals case. In the
That microphone. Again.
So, Your Honor, when I was researching on another case for another issue, I came upon a case, Schaffner versus Schaffner. It's a Court of Appeals case from Nashville. The citation is 181 Southwest 3D 703. In that case, it was a divorce case. There were medical doctors, parents. They have 3 children. The trial court found, and the trial court was upheld by the Court of Appeals. They found that both parties had faults in them, which you found in this case. Although the father had more serious issues there. The father was found to have physically abused one of the children. And the list went on and on for both parties as far as negative things about them. But in the course of their divorce, the father, according to the courts, both the trial court and the Court of Appeals, the father demonstrated that he had the willingness to change, albeit he was arrogant and all these things. The actions spoke. And the Court of Appeals even said, the record showed that the father demonstrated a genuine desire to be a better parent, while the mother refused to recognize her own shortcomings or the effects that those shortcomings had on all her children. The courts eventually awarded the father primary residential on one child, and then the mother, they split the three children, which doesn't happen much. But in this case, they felt the need to split the three children. And then the courts went on to say that parenting plans should never be used to punish or reward the parents for their human frailties or past missteps. And that's what we're asking the court. We're not representing that father is perfect. He, in his testimony, had admitted to his shortcomings more than he wanted to in the beginning. But as you know, true of everybody, like in my childhood, my mother would ask me to clean the kitchen. I was the youngest with 4 brothers, so you can imagine how many tasks I had to do. And so I would do it begrudgingly, but I would still do it because I knew I had to do it. And I feel like this is what we're seeing with my client. He comes off as the, all-knowing, and he would, he would admit that he thinks of himself highly and all these things. But you will see in his actions that he has a genuine desire to be a part of this child's life. He has bent over backwards, and he will continue to do so. And evidence had proof showed that it was Mrs. Graham who is guilty of physically abusing the other party. And whether that rises to the level of domestic, we're not there. My client chose not to call the police on her. Proof showed that it was Mrs. Graham who had been overly aggressive towards this child. We heard the recordings. My client admitted that he was not very particularly proud of those. Those were all in the past. And here and now, we're not saying that those should not be considered. But also, I'm asking the court to consider the things that happened after that. There's no proof here that the child was subjected to any unsafe situation except for that gun situation where my client agreed to not bring the gun. He has demonstrated, like in Schaffner versus Schaffner, that he is willing to listen, he's willing to participate, maybe sometimes begrudgingly, but he would do it. On the other hand, the court will have to consider the factors here, best interest factors. Mother has continued to show alienation, and it's almost rising to the level that she just wants to terminate my client's rights. Because she still wants 0 visitation for my client. It's almost like pulling teeth when my client wants a supervised visitation. And so I think that we have showed Your Honor that, and you pronounced yesterday that both parties have faults here. And again, there's no proof to show that my client is not fit per se to take care of Pearson unsupervised. It could be that it needs to be gradual just because they haven't had overnight visits. He has a suitable home. He has been providing for the needs of Pearson as much as he can, whenever he can. There's just no proof at this point, I believe, to justify the supervised visits. That's all, Your Honor. Thank you.
Mr. Hawley?
Sir, I know this may seem like a final hearing. We are at a temporary hearing in this case. I think a lot of this boils down to credibility. This court has already given us some findings of fact from yesterday. I think that Mrs. Grammon's credibility definitely holds over Mr. Grammon's credibility. You've heard for one thing, the audios that have come about. If she hadn't recorded that, that would have been a flat out denial. You would have never heard of any of this. The mother has consistently been the caregiver of this child. The status quo was with the mother. You've heard the testimony that he never changed a diaper. You've seen the pictures of him. She's trying to show you that at a birthday party while they're eating cake, he's on the couch playing with his phone. That he has been recently smoking marijuana and drinking quite a bit to the point that he passes out. She cannot get him awake. The audios that you heard were recent, a couple of months of them actually separating. Their testimony has been, and it's been consistent, that Mr. Grammon is on a progression, getting worse and worse and worse. The anger and the anger management problems that Mr. Grammon has have been evolving to the point that she couldn't live with him anymore, and she separated. Started out, I guess the physical violence, what you heard, Judge, started out with cats, dogs, whatever, migrated into, Mrs. Grammon, and it gets to where it is today. I have people come in the office all the time, and I tell them there's two factors actually that this court, and I know this court will consider them every day, that if you're trying to deprive a parent of visitation, it's gonna, the pendulum's gonna swing the other way when you get to court a lot of times in situations. And I constantly tell people in my office, you need to give some visitation. It's something where you need to give some weekend visitation. There's gonna be a price to pay if you don't. When they played the recordings for me and they told me the situation with Mr. Grammon, in my defense, I couldn't very well say that. The last thing I want is to talk them into giving some unsupervised visitation and something happened, and then that's going to be Reese Holly's problem because I talked them into doing it, told them they had to. I didn't feel comfortable with it, knowing what I know, and you know everything now that was told to me in my office and was shown to me and played for me. And, it's the court's decision at this point what to do in this child's best interest. We fully agree with psychological evaluations all the way around. If Mickey Smith will take this case, I think it would be a blessing. Everything that this court...
He will. I've already talked with her about it, and Ms. Smith has confirmed that she will take the guardian ad litem appointment.
Again, I think that would be a blessing to both of these parties to have a little Mickey Smith in their life, and my client's ready to definitely cooperate with that. The problem becomes from, as you hear from Mrs. Grammon and from all the witnesses, her mother included, that had to sit there at the church with a gun. It's an evolution of anger, and that's how he deals with it. I mean, he didn't, at a visitation with just the mother, and this court asked those questions, there was nobody else in the building, but he felt like he had to put a gun in his back and pull his shirt up where she could see it, pardon me. That was nothing more than an intimidation factor. But my question becomes, as it is in these cases, what happens if Pearson destroys a charging cord? What happened if Pearson grabs something and runs off with it like the dog did? At some point with an evolution of anger in this situation, does Pearson get chained up to a jet ski? He's got to learn how to deal with what's before him and how to deal with a child in these situations. He's not done a very good job of that. The track record is horrific to the extent that you're listening to the audio recordings that you've listened to, and his wife has left him, and the families are at odds, and all of those things. But for the anger of Brian Grammon, we wouldn't be here, I don't think. I don't think it would have been a separation. we're asking for the status quo. That my parenting plan be adopted. The court lay down some sort of supervised visitation. Dr. Berryman will do it. Again, I think that would be a blessing. If not, let's get somebody for a psychological evaluation and somebody that can follow the recommendations of whatever those psychological evaluations may be, and somebody that can take charge. He's got great insurance from what I'm hearing that both parties can use, and somebody that can be involved on a day-to-day in the life of, whether it's Mickey Smith or whether it's the psychiatrist or psychologist that we choose, to introduce different types of visitations and different types of things when Mr. Grammon is ready. That would be, in our opinion, the ideal ruling, and let the professionals handle it, let them deal with how he needs to be dealing with his anger and help him with it so that nobody has these issues, and let them control the visitation. If they say unsupervised, then let them do it. Let them be in control of everything as far as that goes. We're asking for the status quo, especially until we get the psychological evaluation. Obviously, the drug test, I noticed he didn't take one when we came to court. I don't know if he will pass the thing or not. I'm sure with the court dates and everything upcoming that, you kind of refrain from those things with the knowledge that you're going to be doing this stuff. When the immediate separation hit and all these things started, I noticed we didn't have a drug test during that time, although he did do all the other things. And the other things were with Main Street interventions. The court can take judicial notice. You've used them. I've been around them for years, and they do a great job. But Mr. Grammon's river runs a little deeper, and I think he needs more than a questionnaire to be filled out and those types of things. You said you're going to order that psychological evaluation. I think that's, again, a blessing for both parties. And I appreciate your time for hearing this case.
Anderson, you have the right to open and close. Anything else?
No, Your Honor. Thank you. I do think, Your Honor, you're gonna give your ruling and then we move on to the other motions that were filed in this matter.
And the other motions are?
I think I have a motion to enlarge the discovery request, which I'd be happy to discuss
A
it
motion
with.
to enlarge the discovery request.
Yes, Your Honor. I previously had a motion to compel. I had a motion to compel, and then I followed it with a motion, and then Mr. Hawley filed a motion to quash my second set of discovery. And then I followed it with a motion to enlarge the number of.
Well, let's go ahead and deal with those. I'd like to
Discovery
just make
requests.
one ruling on all of the issues. So your first motion is a motion to compel.
And Your Honor, this is basically hand in hand with the motion to enlarge. I previously sent my first set of discovery requests to Mr. Hawley. It had 51 questions, not including subparts, but the subparts were related to the subject matter being asked on the individual questions. And then I got the discovery, but then there were 9 items that I listed in my motion to enlarge that were not answered. And so what I did was I sent a second set of interrogatories and requests for production and included those items that were not responded to, and then also added new questions based on the answers. And then, so that's when I filed that, sent the second discovery, and then Mr. Hawley filed a motion to quash. And then I filed this request and a lot of these questions now have been answered from our hearing, but I'm still missing medical records of Mrs. Grammon. She has testified that she has seen a therapist during the marriage. She didn't divulge that name in her answer. And now we found out that she did see a therapist. I included a medical authorization release form. I have it here. If she if Your Honor would be agreeable, she can just sign this and we'll send it to the therapist. And then the rest are questions about her actual employment, which she already responded to. And so that's my motion.
Holly?
Sorry, I'd file kind of like a motion to quash the, I don't know how else to phrase it, the set of discovery. We have a rule. And I was in the room when it got invoked in 2000, I remember it well, 2006. Right after the election, Mr. Potter brought it up and Larry Wallace seconded it. We were all in there making rules to our amendments to our local rules. And one was that discovery would only have 50 questions, including subparts.
Ever heard the term that a rule is observed more in its breach than in its compliance?
I understand.
You ever see John Belushi when they were playing the Killer Bees on Saturday Night Live and said, "We don't need no stinking rules"?
Yeah.
Actually, he said no stinking badges, but this is a case, I understand your objection because of the multiple questions being asked. This is a case that's going to, obviously not going to be resolved by agreement because these parties can't agree. But in other words, in my opinion, there's no reason not to allow these additional questions and to expand it. The local rules are that, and those local rules provide that the court may waive them with discretion. In this particular case, let them all have it. Let both sides put as many questions out there as they want to. I think it would be better for them to have full disclosure than it would be to limit what they're asking. And if there are questions about her therapy then my suggestion would be the following. If there's going to be a therapist records that are going to be requested out of confidentiality, and those therapy records are usually confidential, and the same thing's going to apply with these psychological assessments. They're going to be filed with the court, and they're going to be filed under seal. And only people who can get access to them are going to be the attorneys who represent the parties and the court. And by doing that, we're preserving the confidentiality, and the parties need to know that if they are giving full disclosure to their therapist or to the psychological examiner, that's not something that's going to be bandied about unless there's a need to do so that the court finds is relevant. So I'm of the opinion as to this therapist issue, Ms. Hendrickson, that there probably needs to be an agreement that her therapy records will be produced either by judicial subpoena to be filed with the court, and then you will have permission to review those records. You cannot copy them, but you can review those records, and Mr. Holly can review those records. And if there's something in those therapy records that you feel like would be relevant for a final hearing, then you can file a motion asking the court to allow you to do that, and we can have an in-camera hearing where I can review the records and I'll make a determination as whether or not that's something that's relevant enough to unseal it, so to speak, and go from there. But I don't see any reason that Ms. Hendrickson's request for additional information can't be reasonably agreed to. So let's go from there. So.
And in the judicial subpoena, the records show up here, is it, Your Honor? And I've done this a couple of times with this court. Usually it's the order that I can look at them, Ms. Hendrickson can look at them, but we can't even tell our clients until we file that motion and come back in front of you. We can't talk to our client.
You cannot reveal what's in those records until after you've got permission from the court to utilize them. And if there's a lot of extraneous information that has nothing to do with this case, then there's no reason for that to be that breach of confidentiality. If there is information in there that's relevant on the issues before the court, then you can apply to have that information provided.
I just know we're gonna have this, but even to our own clients, we can't say anything. We've got to come ask you, and then we can talk to our clients about what's in the record with each other, so.
You as officers of the court are under a sworn duty to follow the court's instructions, and as you well know. So what I'm doing is simply saying, this is about discovery. So if you discover something in those records that you feel like is notable and usable in the case, then and only then can you come to court and say, I want to use this information and I want to disclose it to my client. I'll consider it and I'll give you permission or I'll deny that. depending on what I think it is.
The biggest question comes up is, why can't I tell my client? We always say that. I just want to make sure we're clear.
The clients are
Ms.
sitting in the
Henderson's clear.
courtroom and they're listening to what I say, I hope. And so for that reason, what I say applies to them. Your lawyers are officers of the court, and they're ethically bound to follow this court's instructions and not to do what necessarily their client wants in this situation. So, all right.
And that pertains to the discovery request now is wide open on both sides. May I have 30 days to answer what I've got in front of me with the second set of discovery at this point? So I'll round that up and get it to
Both of
her.
you fire away.
Thank you, Judge.
Fire and fall back.
Judge, the only request for your consideration is I have previously sent a draft agreed order to Mr. Holly, basically asking for the parties to not expose the child to any person of romantic relationship or anything like that until this matter is resolved, if you would consider that. And that's
Okay,
all.
well, you gonna make that a part of your final, are you gonna make a closing argument on this case? We're ready to take up your argument. Have you already done enough of that you want? So the only other thing then is your request to have a mutual prohibition in the final order that prohibits either of them from making that, allowing the child to be around someone that might be construed to be a paramour. Do you have any objection to that?
I know there was a motion before the court for that right now.
It was not it was not a motion. I sent you a draft order, agreed
It was a
order.
proposed agreed order.
Proposed agreed. And the reason why we're asking that was the issue of the child calling my client his full name, Brian Graham, at some point, and then it changed to Daddy. So he wanted to make sure that the child doesn't have any ideas that he's being replaced or anything like that.
There's not a problem with this on our side. I think this is something that's thrown out there to make my client look like something's wrong. There's nothing wrong. She's not seeing anybody. There's never been any evidence to that effect. But if that's what we need, is an agreed order from Ms. Henderson, we're fine with it.
All right, we can put that in your order. All right. Ms. Hendrickson cited the case of Schaffner versus Schaffner of the 2004 Court of Appeals case that was cited at 181 Southwest 3rd, 703. Mr. McKinney has pulled that case for me, and I've reviewed it. And the part that Ms. Hendrickson quoted was, parenting plans should never be used to punish or reward the parents for their human frailties or past missteps, and that's very true. What was not quoted was the preceding language, so I'll quote that now. Court of Appeals stated as follows: creating a parenting plan is one of the most important decisions confronting a trial court in a divorce case. Courts must strive to devise parenting plans that promote the development of a child's relationship with both parents and interfere as little as possible with post-divorce family decision-making. The needs of the children are paramount. The desires of the parents are secondary. Parenting plans should never be used to punish or reward the parents for their human frailties or past missteps, but rather they should be used to advance the children's best interest by placing them in an environment that best serves their physical and emotional needs. There are no hard and fast rules for devising a parenting plan. The process is factually driven and requires the court to carefully weigh numerous considerations. The Tennessee General Assembly and the courts have identified many of those factors that the courts must consider, and of course they quote the Tennessee Code factors that are set forth in 36.6.106 of the Tennessee Code. Trial courts have broad discretion in fashioning parenting plans that best serve the interest of the children. They must, however, base their decisions on the evidence presented to them and upon the proper application of the relevant principles of the law. So therein lies that is a complete reading of that Court of Appeals decision in the Schaffner versus Schaffner without relying on what they actually did in that particular case, because that case was more about issues that weren't directly about it. It was a different judge had come in and taken over a case, and so much of the case is deciding with or dealing rather with a successor judge and how he handled the case. But there was that applicable information. So it is not this court's intention to punish either side in this case. Neither of you is perfect. I rarely see a case in this court that reaches this point that one side is without fault and the other one is completely to blame. Rarely ever, and in fact, I don't think I've, in now almost 9 years on the bench doing this and all my years as a lawyer, I don't think I ever had a case as a lawyer, nor have I had one as a judge where one person was completely and absolutely completely at fault. There is one that comes to mind, but that person is presently, that defendant is presently serving prison time for sexually abusing his daughter. And to my mind, that's the one case I can call to mind where all fault lay on that person's side, despite his efforts to try to say it was his daughter's fault for him sexually abusing her. In any event, I digress. This is not particularly an easy case, and I want you both to know, and I take it very seriously. At 3:30 this morning when I awoke for some reason, first thing to my mind was, how am I going to deal with this case? I have already appointed a guardian ad litem. Mickey Furlong Smith is the attorney that's going to represent the child's interest in this case, and I think that's an appropriate situation. I previously ordered that a psychological evaluation for both parties they'll undergo that. We'll hope that Dr. Janie Berryman can do it. If she can't, she'll refer them to someone. I want them both to undergo a parenting assessment. Parenting assessment is different than a psychological evaluation. Psychological evaluation is designed to determine and to identify if there are psychological issues. Hopefully, if Mr. Grammon has, gotten hold of his anger issues, and there clearly are anger issues by his own admission, then that would be one thing that the court can consider what he's done so far, and the psychological evaluation may determine whether there's a need for additional steps to be taken in that regard. But the parenting assessment is something different because it does assess the abilities of both of the parents and what their needs are in improving their parenting skills. As I said yesterday afternoon, Mr. Grammon is this child's father. He has a right to see this child. I understand you don't like him anymore, you don't love him anymore, that you don't want to be around him anymore, but the child has a right, and I just read to you that my obligation under the law is to fashion a parenting plan that will allow the child to have a good relationship with both parents. This is a temporary parenting plan, so therefore it is not the same standards, so to speak, as a permanent parenting plan. But nonetheless, I'm being asked to determine, Ms. Hendrickson, on behalf of Mr. Grammon, has asked that the court fashion a parenting plan that gives equal time with him and designates him as the primary residential parent. So I'll look at these factors that the code has set forth for me to make this determination that I'm required to look at. Those are set forth, as I said, in 36.6.106 of the Tennessee Code. The first one is the strength, nature, and stability of the child's relationship with each parent, including whether one parent has performed the majority of parenting responsibilities relating to the daily needs of the child. Clearly, Mrs. Grammon has performed the majority of the parenting responsibilities relating to the daily needs of the child, and the court finds that factor favors Mrs. Grammon. Second is each parent or caregiver's past and potential for future performance of parenting responsibilities, including the willingness and ability of each parent and caregivers to facilitate and encourage a close and continuing parent-child relationship between the child and both of the child's parents, consistent with the best interest of the child in determining, that factor, in my opinion, doesn't favor either of these parties, because I don't think that either of them have shown a willingness and an ability thus far to encourage a good relationship with the other parent. There's too much animosity and hatred, I guess you could say, outright between them. As a result of that, and while you can come up to court and you can testify about all of the changes you've made in your life, you have to understand that the court doesn't just judge it from what I read in the file and what I see from the witness stand. I also observe people in the courtroom. I observe how they act and how they react to testimony in the court. And frankly, the testimony has been about this gun episode. I will say this, that clearly, and it goes to other factors set forth in the code, but this situation of the need to carry a pistol demonstrated in the back of your pants during a visitation with only your mother-in-law and the child in a church that's otherwise deserted is ridiculous. You have every right to carry a gun, but to carry it to a visitation with your minor child is intimidation. And that the court finds was an effort by you to intimidate the supervisor of that visitation. And the court has observed in this courtroom yesterday during a lull when we were waiting for someone, I observed Mr. Grammon staring at Mrs. Grammon across the room. And that went on for quite some time. And the only reason for doing that for that length of time was, in this court's opinion, an attempt to intimidate her if she looked at you. You may not have understood that I was observing you, but I did. And, you know, that kind of stuff is high school stuff. It doesn't need to be in your life anymore. You're going to get to see your son. We're going to move to that situation. You're going to have, at some point in your life, unless there's some factor that comes back up, you're going to have a liberal visitation with your child, regardless of who the primary residential parent is. But you are not going to be able to intimidate her anymore, because I'm the one who's going to be making the decisions, and you certainly don't intimidate me. So I'm just telling you, stop that if that is in fact what you intend to do. And perhaps I've misinterpreted it, but it certainly appeared to me that's what's going on during the supervised visitations. I've dealt with the fact that will no longer be allowed. You will no longer be allowed to take a gun to the visitation or to demonstrate it, and we'll go from there. You have a right to have a gun on any time you want to, except your rights are subordinate to this court's obligations regarding your child. When you two can't agree on something, you surrender certain rights to come into this court. And that's one of those, is the right to make decisions for your child. I have to make them. I don't want to, but it's part of the job that I've assumed. So I'm just telling you that everything you do is part of what this court has to consider. So that's a factor the court doesn't find, because Mrs. Grammon has simply said she'd rather even not see this child at all. She's following her lawyer's recommendation, because Mr. Hawley knows that he's got a right to see them. But she's indicated that she doesn't really want him to see the child. That's going to have to change, Ms. Grammon. You're going to have to come to grips with the fact that you had a child with this man, and the only time the termination of parental rights is one of the most severe things that can occur in any person's life. Is one of the highest burdens upon a court to terminate a person's parental rights. We have all sorts of rules and regulations. It requires clear and convincing evidence. And that's the highest standard in a civil court, is clear and convincing evidence to terminate someone's parental rights. So you have a father of your child that you're going to have to deal with for the next 16 years. And you better get used to that idea that you're going to have to deal with each other. And that goes with you, Mr. Grammon. So court finds that there's been no refusal to attend a parenting educational seminar. He has done so. I don't remember if she has or not, but she'll have to do so before the conclusion of this case. The disposition of each parent to provide the child with food, clothing, medical care, etc. She's been the one who's primarily taken the child to all of the doctors and taking care of feeding and clothing and bathing the child to the large extent. He has participated, but he's also provided some support voluntarily without a court order, and that goes to his credit. The degree to which each parent has been a primary caregiver, I've already determined that she was the primary caregiver in the past. The love and affection and emotional ties existing between each parent and the child. I hope that Mr. Grammon is truthful and honest with me yesterday when he said the only thing he's ever wanted in his life is to be a parent, to have his own child, because that is one of the most awesome things you can have happen in your life, but it's also one of the most challenging things that you can have. Your child is now in the so-called terrible twos, and it's going to be a challenge from this point on for both of you to deal with a child like that. And it's going to get worse, because he's going to be going back and forth at some point between your homes, and children start to manipulate their parents by their behavior when one parent lets them do something the other one doesn't. So you better get used to that idea. But both of you, I think, love this child, and I think both of you have the desire to have a good relationship with the child. So I think that's an equal factor for both. The emotional needs and development level of the child, this is a 2-year-old child. I don't have any indication that there's any problem with emotional needs, so that doesn't really apply in my decision. The moral, physical, mental, and emotional fitness of each parent as it relates to the ability to parent the child. This factor causes the court some great concern, and that's the reason I've ordered the psychological evaluation. You cannot listen to the tape recordings that were made, the audio recordings, and I'm not naive enough to think that someone who's going to record someone who's ranting and raving of their partner, is going to avoid engaging in that same type of behavior. In other words, rarely ever are you going to see someone who's going to record something that goes off and starts using the same type of language. They record you at your worst, and they record themselves being very calm and mild. And there's nothing wrong with that. I'm just simply saying that I also understand that that shows only one side of that equation. But it cannot be that you can listen to those recordings and not determine that Mr. Graham has some issues regarding his anger and his behavior. And therefore, that's the reason that I ordered a psychological evaluation. And I wanted to have a psychological evaluation of both parents for that very reason. I find that that factor favors Mrs. Graham at the temporary hearing, and we'll see what the psychological evaluations reveal. I don't find that there's any interaction with siblings or other relatives with this child that would affect my ruling. The importance of continuity in the child's life, the length of time the child has lived in a stable, satisfactory environment. The child has primarily been with Mrs. Graham, and that factor favors her. Evidence of physical or emotional abuse to the child or to the other parent or any other person. There has been evidence on both sides presented, and both sides have testified. Mrs. Graham has candidly said, yeah, I've slapped him, or I've hit him, that it was in self-defense. She testified she kicked him because she was exhausted and laying on the bed, and that situation happened. He says that she has laid her hands on him, those are his words, and that she's physically abused him. That very well may be. I don't find that the credible testimony before the court substantiates that Mrs. Graham has been physically abusive towards him. I also don't find that there's been physical abuse towards this child by Mr. Graham. There has been clearly some evidence of physical abuse. I have to judge credibility from what I see. And when I hear that Mr. Graham, who is substantially larger than his 4'11", 187-pound wife, says that she has physically abused him. I'm not saying that can't happen, but it's not likely in this court. It's not as credible in this court's opinion. But in any event, that stops now. There'll be no intimidation, no threats, no violence that will take place whatsoever. Neither of you will physically abuse this child. That'll be a part of this court order. Neither of you will use corporal punishment. Why? Not because I was whipped as a child. That certainly happened to me, and there were times when I was raising my children that I might have felt it was necessary. But you put it in my hands. I don't know you well enough to know what level of physical corporal punishment you'll use. But you're not going to use it now. Period. We're just going to eliminate that as an issue. Put them in the corner, deny other things, but there'll be no whipping or corporal punishment used. The character and behavior of any other person who resides or frequents the home of the parent. There's no evidence before me of any other person. Reasonable preference of a child doesn't apply. The employment schedule doesn't really apply. The other factors deemed relevant by the court. As I've stated, in my opinion, the implementation of the gun and the visitation is a major red flag for this court, and for that reason, the court finds that is a factor that also applies. So all of these factors combined indicate that Mrs. Graham will be designated as the primary residential parent of the minor child on a temporary basis, and this is temporary. I have ordered that a nail bed test be performed on both these parties within 48 hours. There are 2 different labs, and Ms. McKinney has obtained them for you. I'm not going to, one of them is Relia Lab at Suite 109, 3656 Trousdale Drive, Nashville. The other one is Anytime Labs, which is on Wilma Rudolph Boulevard in Clarksville. And either of those is satisfactory. But I think council would probably benefit by having both of them go to the same lab so that there's no question about how the lab performed the test. Both of them will submit to that within 48 hours, if at all possible. If they can't get an appointment until next week, then so be it. But I'd like to try it done as quickly as possible. I'm going to look at those. We're going to continue the supervised visitation for now, and I want to make it clear, I'm only doing that because there's been evidence of drug use. Marijuana is illegal. Other situations, I listened to the recordings and what was said during the recordings about alcohol use. I've also listened to Mr. Grammon, who says he's quit drinking, quit using drugs and that sort of thing. And he clearly encouraged and wanted to take a drug test. So we'll see what this nail bed test shows. Hopefully that'll resolve the issues. The supervised visitation will continue. We'll keep it in the status quo right now, but on November the 30th, I want you back in this court. And I'm going to review the nail bed drug test results. If those come back clean, then Mr. Grammon can expect that I'll move towards unsupervised visitation of some form. And I can't just give you unsupervised visitation right now, Mr. Grammon, without some sort of reassurance that what you tell me is true. So I want to have this test. Now, the length and time of that unsupervised visitation will be up to me at that time, and we'll see how things go between now and then. The behavior that you two demonstrate towards each other between now and the 30th of this month will help me to determine how much visitation, how long, and under what circumstances. But if it does go to unsupervised visitation, and you take your son to this apartment you're renting, he doesn't need to have any contact with the other inhabitants of that retreat. I understand what you're saying, that that's but I've dealt with these kinds of situations long enough to know that those boys are not being sent there for a private school like you would send them to BGA or MBA or some of those other private schools. They're sent there because they have some issues. It doesn't make them dangerous, but it does make them children who have, some sort of issues in the past. So as a precautionary matter for this court's protection of the child, if you get unsupervised visitation, you take your son there, we're going to prohibit him having contact with those boys. It's a simple thing. And I believe that deals with everything that I have dealt with right now. And the court is of the opinion that if the nail tests come back negative, that the parties would be well instructed and advised to try to set up some sort of short unsupervised visitation periods, because what I intend to do, if it comes back clean, and the guardian ad litem is involved and unless the guardian ad litem has some objection, then we're going to start with some shorter unsupervised periods, moving to longer as we go. That's a test run, so to speak, Ms. Grammon, so that you see that. I want to reassure you that your child is safe. I want to reassure him that he has a future waiting out there, that it's kind of like the old carrot and stick approach, where you essentially say, here's what you can work towards, and if you do that. I compliment Mr. Grammon for doing the things that he's done to try to get himself straightened out. He's got a good lawyer, very thorough. That's evidenced, both of them are very thorough, as evidenced by this being the third day of a temporary hearing. But the fact of the matter is that you follow her advice, follow her instructions, as I think you have done at this point, and we'll see where we are on the 30th. But there'll be no guns involved in the visitation, and I strongly urge you to get along with your mother-in-law at this point. She's the supervisor, and let's don't have any kind of problems and so forth, and then we'll go from there and see on the 30th. But I would really hope that on the 30th we can start moving towards unsupervised.
I do have a couple of questions, if it's okay.
I'm up here so I can make sure I hear you.
Your Honor, on the continued supervised visit, we would request for a specific day so that they won't have to have that conflict with trying to arrange. Would that be possible?
Sure.
My client is
What time do
always
you-
off during the weekends, and
What
then
time
he
do
gets
you get
off.
off? You're flexible, right? That's what you
I
said.
can be flexible. I'd prefer to start.
You have a day, right now you're having a day during the week and an afternoon during the week and during the day on Saturday, correct?
Yes, sir.
All right, what day during the week?
It varies between Monday, Tuesday, whatever she tells me.
Tuesdays. We're going to designate the day will be Tuesdays. And
I do want to consider their supervisors as well, just to make sure
That they're okay with Tuesdays.
I can check. Before, it's been kind of with what the supervisors can do. We got the Fords and then her mother. I'll
take a recess. I want to designate one day, one afternoon during the week, and Saturday for the length of time, Saturday that's been doing from 10 to 2, I think is what you've been doing. That's temporary, and keep in mind, this is all until we come back on the 30th, okay? So between now and
every
then.
weekend, every week.
Every week, he needs to see the child 2 times, one during the week, one on the weekend. It can be Saturday or Sunday, but I'll take a recess and let you all try to work that part out.
I do have one more question, Your Honor.
Right of that.
I have been researching the nail bed, and I can't find where it says how far back it goes, because my client did testify that he had his last, I want to say May-ish. So I just don't.
Your client
if
testified he was willing to take a test and let it go back as far as it possibly could.
I'm
We're going to take him at
yeah.
his words.
But we don't know how long that goes for.
I don't offhand, but I'm understanding that it may go back as much as 6 months.
I'm fine with that.
That's all, Your Honor.
Good
Thank
with
you.
that.
I think you kind of have to order both parties not to cut their nails till they can go take the test. My problem with those is everybody comes back with insufficient
Well, I'm
samples.
inclined if they cut their nails, we'll just pull them out. So-
Well, that's what they do at the nail bed place. I mean, I've seen some of them come back with just bloody it's one of those things. Anyway, if this
I've
works?
actually had cases before me where somebody was ordered to take a hair follicle test, and the next thing you know, they have shaved every hair on their body. A man shaved every hair on his body, and to avoid being able to take a hair follicle drug test until it delayed it, but didn't.
My favorite was the,
Toenails, Your Honor?
they will.
Because he's got really short fingernails, but he's got longer toenails. I just want to make sure, Your Honor, I'm being transparent here.
No, they will use
Might not
toenails.
Mr. Graham might not want to bite his fingernails because they may take a pair of pliers and pull on those fingernails. So
That's what it takes to get piercing done.
Okay.
Well,
I think they would take nail bed of any
Okay.
kind, toenails or anything else. So just don't clip your toenails short.
it would be agreeable with a couple of days' notice somewhere where it could be Tuesday or Wednesdays, and we can get one of those.
Sorry, what?
A couple of days' notice, maybe we could do a Tuesday or Wednesday. We'll do one of those 2 days.
You're
by
going to
the
decide
agreement.
that today. We're not leaving here until you two have decided what the days are going to be. So you're going to stick around, you're going to find out from these supervisors by phone what day they can do it, and we're going to set that as a part of the order, because all it's doing is the next thing I know, you two are not going to be able to agree for some reason, and then I'm going to be getting phone calls or messages that the visitation can't be agreed upon. We're going to fix that today so that it's set and certain.
And the duration for the visit, how many hours?
The duration of the visit has been, I think, in the afternoons, 2 hours on Tuesday, during the week.
3 hours, Your
2
Honor.
hours, 3 hours,
Well,
2.5 hours.
Well, if
2 or
it's
3
only
hours,
twice
you
a
tell.
week, we would ask for 3 hours.
Ms. McKinney has printed out information about the nail bed test to give you so that you can understand what it is.
You know what we would propose for the weekday, 3 hours, and then Saturday, 4 hours.
I don't think I have a problem with that. I'll talk to them.
3 hours in the week, 4 hours on the weekend. You all talk to these supervisors. I am fine with it being between now and the 30th. One day during the week, designated Tuesday or Thursday, whatever you want to do. I figure Wednesday is going to be church night at the Alexandria Church of Christ. It's like the Churches of Christ I grew up in. They're going to have church services, so it's not going to be a good time to do it. But if you do it Tuesday or Thursday, one of those 2 days, just do that day, because that gives you time in between the Saturday or Sunday visitation. So you can do Saturday one week and Sunday the next week if you want to. I don't care, Sunday afternoon or whatever, but I think it makes more sense to do it Saturday. So my inclination is see if you can get your folks to agree to Tuesday afternoon for 3 hours and Saturday for 4 hours.
So we want a Tuesday or Thursday and then a Saturday, and if not, they can go to Sunday. I think we can work that out without you taking a recess, I would hope, so. I'll be glad to do that.
This information says on average, most drugs detectable in fingernails beginning at approximately 7 to 14 days after use and extending as far back as 3 to 6 months, depending on the length of the nail clippings that are collected. Confirmed positive result for a drug or drug metabolite is considered evidence of use or exposure in that time period. Note, toenails do not grow at the same rate as fingernails, therefore the window of detection is less precise. This test requires the clippings of all 10 fingernails or 10 toenails. Fingernails and toenails should never be mixed in the same sample. All right, so nobody clips their fingernails or toenails between now and then. Is there anything else I can address for you folks?
Can we make sure we have an insurance card from his insurance for the psychological evaluation?
Insurance cards need to be exchanged.
And then guns, or can we say any other weapons at the visitation? You heard her talk about
Knife needs to
knives.
stay out of the visitation as well. There's no, I mean, I understand that's probably a belt knife or something like that, or maybe one of those clip-on folding knives like whatever, or utility knives, but just leave anything that might be interpreted as a weapon outside during the visitation. That goes for your supervisors as too. I mean, this goes to the Fords or anyone else. They don't bring knives or guns to this as well. So.
November 30th, I'm having some outpatient surgery on the 27th. They tell me I'll be going home that day and all, but I may be out for the week. I don't know that I will, but just as a safekeeping, if we do this on the 30th, may I do it by Zoom?
Yes.
I mean, things I've got that.
This is just for me to try to give, to see what the results are, hear from the guardian ad litem, see where we are on the psychological evaluations, and if there's no presence of drugs, you know, or that would cause concern, then, you know, I'd like to then go ahead and try to start towards some sort of.
What time would that be, Your Honor? Because I'll be in Davidson County in the morning, but I should be done after noontime. Can we be put in the after second call?
30th.
Plenty of stuff to go.
We have a big docket that day, so if you need to go somewhere that morning, Mr. Holly will probably be in his pajamas that morning anyway if he's had surgery, so we'll see if we can get him up and dressed in time for that afternoon.
Mr. Holly hopes to be asleep right here, but just in case.
Just let the clerk know what time, but we'll be here at least at 1:30, so.
Thank you, Your Honor.
Anything else?
You want me to actually go check and come back in real quick?
Yeah, I've got another case that Mr. Atchison is involved in. We're going to take a recess before we get to it.
I'm sorry, Your Honor, we forgot one more thing. The phone calls twice a week.
Do what?
The phone calls or FaceTime twice a
That's
week.
standard parenting, and if you can do a FaceTime call, that's even better, although that may not necessarily. You got a 2-year-old, and my experience with trying to FaceTime my 2-year-old grandson is that there's not a lot of cooperation on his end. He kind of stares at the phone and then wants to go play. But phone calls with a 2-year-old are not going to be great, but you can try the phone calls over FaceTime, whichever way it works. State parental rights is for at least 2 phone calls per week. So,
Thank you, Your Honor.
before I stand up, Senator, is anything else?
No, I did not need anything else.
We'll take a 15-minute recess.
All rise.
Thought I was finished with you. Did you agree on your schedule?
I thought I could leave, I already would have, if that helps. Yes, Judge, Tuesdays 4 to 7, Saturdays 10 to 2. If we can put in there or by agreement of the parties, if somebody's sick or whatever, they can text and make an arrangement, but if they don't have an agreement, those will be the dates and times.
All right, and that is true, Mr. Holly. What Mr. Holly states is the general rule, and that is this becomes a court order, and I'm going to approve it today, so it becomes effective now, right now. And that means that if you're in agreement with that, that's fine. If you don't agree and you need to change something about it, it has to be by mutual agreement. And that probably needs to be through the attorneys, although you can do it by text message or something like that, if that's what, just needs some sort of written verification that there is an agreement to alter it. But unless you two can both agree on a change, then you're stuck with that. So, all right, good luck to you. I hope this all starts to calm things down between everybody, and that everybody starts to realize that you got to live the rest of your life. And the way that tensions and emotions are right now are going to make it very difficult for you to have a productive life and for your child to have a productive life, unless you can kind of calm things down and start moving in a more positive direction. So good luck to both of you. I hope it works out. And we'll see you on the 30th.
Thank you, Judge.
And who is drawing this order?
I'll draft the order, Judge.
Send it to me. I'll draft the order and submit it to you for your approval. Office and then join us on Zoom.
If I may, I don't have a fever. I've got a head cold. We passed it around the house, so.
Pass it around the house is not a recommendation to have you sitting in the same courtroom with all of us right here before Christmas.
I'll do whatever you want me to do.
What do you have?
I have, and more or less on my end of it, maybe 15 minutes of the review in the Grammon case.
Is that all you have left after the case we're resetting?
It is.
Well, let's take that up, and Ms. Roberts, if you want to vacate the courtroom, or anyone else who wants to leave the courtroom while Mr. Holly is here, and that'd be a good idea to wear a mask.
I'll be able to watch Fox News again if I wear a mask.
Well, that might be a blessing in disguise. All right, this is a review on Grammon versus Grammon regarding the prior orders of the court. Has the order been entered from reflecting the prior order? Okay. The last time we were here, we had ordered that there be, I think both sides be submit to drug tests. Is that correct?
Yes, sir.
And my understanding is that from what I've seen, and I don't have it right in front of me, but that well, I have the drug testing for Mrs. Grammon, and all of that was negative, if I understand correctly. And then I have the drug testing for Mr. Grammon, which was collected on November the 3rd, and showed it was positive for cannabinoid, whatever basically, and positive for THC. So he had a positive drug test on the collection date of November the 3rd. Then I show another test on November the 17th, and that showed negative across from what I'm looking at, all of the possible metabolites and all of the possible drugs that might have been tested. So on November, may I see the docket sheet, please?
That's the one that I wrote in notes on that I think it's in the office. Do you want those orders that you had signed?
I want to see the orders that were prepared before we go further. But under the prior order of the court, according to this, what I'm looking at, after the order requiring them to submit to a drug test, and that order was entered on the 31st day of October. So they were both within 48 hours of the court hearing were to submit to a says a nail follicle, but I think it was a nail bed test, but in any event. Then after that, it was giving the father to have supervised visitation with the current supervisors from Tuesday at 4 to 7, and then Saturday 10 a.m. to 2 p.m. And we had set the review allowing you to participate by Zoom at 1:30 on November the 30th. I don't think we got to it on that day, but all right. Either side wish to be heard. This is a review after having ordered the drug test results. You want to be heard on that?
You did. I made remember, Mr. Graham testified that he didn't use cannabis, he would pass it, he welcomed the drug test, and then it turns out that he did fail, that they were high levels. The other was a hair follicle drug test that he took after that and not what the court had ordered. So that was concerning. The court has laid out some groundwork for these parties and gave them, quite a discussion the last time that we were in court and got all of the evidence resolved and Your Honor was given the ruling. You did set it for review on that other day, and I was here by Zoom. There was recordings, and Ms. Smith was involved. She testified they were disturbing to her as well, and you were wanting to maybe have those heard in court rather than hear them on Zoom on that day, so it got reset for today. I would have, if the court's inclined, the supervision at the church, if the court remember they were going to a church, the supervisors are her mother and the pastor basically of the church. They have some concerns, and she's here to testify about vaping in church and doing some things of that nature while having a visitation. Mr. Graham was vaping in church. I have audio recordings that Ms. Graham can verify. They were done, I believe, on around maybe the 8th of December, and they're quite disturbing. To me, she's threatening her existence. I mean, I think that's the way Ms. Smith kind of took it. I would like to play you those, and just my thought with these recordings. After the court gave the discussion that you gave with these parties, we still have this situation. And lastly, the psychological assessment with Dr. Berryman, she is going to do both, is doing both. I know my client's been once and is going again tomorrow. So my understanding is it's kind of the way Dr. Berryman set it up. Coming in stages, she wants to see the child, the interactions with the child and the parties and everything. So it sounds like we're going to get some pretty good reports from her as well. With the court's indulgence, I'll play this video.
I'm going to hear from the other lawyers. If you're going to wear a mask, wear it while you're talking to the court as well. So.
Yes, sir.
Ms. Hendrickson?
Your Honor, I think when we were last here, I did brought up to your attention that the recording that is going to be played is just taken out of context. The parties, after we concluded the 2.5-day temporary hearing, they started communicating and they would talk for hours. And at some point, there were talks about possibly slowly reconciliating, but that fell apart. And during the testimony there, it was clearly shown that my client exaggerates, and even wife admitted to that. And this is going to be another of those recordings where wife would say something to the father to the effect that she will be replacing him as a father. And of course, that will set off some words there. But we will not hear that recording of when she said those things to my client. We will only hear the recording of my client, and that's where we're at with that. My client has seen Dr. Berryman. He is going tomorrow again. As far as the drug test is concerned, even though my client volunteered to have the drug test and say that he will pass it. He did say that his last use was May of this year. So the slightly positive result, which is very negligible on that nail bed test, that was to be expected. But then he went ahead and subjected himself to a hair follicle test about 2 weeks later, and as you mentioned, that was negative. The visits are going well. I have not heard of any vaping incidents, so I'm, have yet to hear about that. He's in compliance with your order about not bringing any weapons of some sort. He's been seeing his therapist, Miss Weismark, and he will continue to do that to help him with communication. At this point, Your Honor, my client concedes that there are grounds for divorce in this case. We have alleged inappropriate marital conduct. I believe Mr. Reese did too. If the parties will agree, my client requests that they be declared divorced today. He believes that that will help alleviate a little bit of the communication about whether do we stay married or
Give them
not.
what they want, that way they can really fight it over the things that they still want, right? 'Cause if
Yeah,
they-
that's our intention, is just to limit communication about the custody, and maybe there's some property there that needs to be.
Well, the reason I'm saying that is because one of our former judges that I used to practice in front of, he said, well, I'm not going to grant them a divorce by agreement. That gives them what they want. Then they'll just spend all their time fighting over stuff instead of trying to settle it. If they want the divorce, they might try to settle it. So that was his logic anyway. I'm not saying I agree with that, but the other option is that if I hear the case and they're both at fault, then I can dismiss it, leave them married.
I'm not sure about that, Your Honor.
I am sure about that. I'm sure that's within my power. I'm not sure that that would be a good thing, because it basically is a remedy that's very infrequently used.
And so, Your Honor, with that request, my client would still request that the previous order where they are not supposed to expose the child to any third party while the litigation is ongoing. He would request that to continue. If you
Why do you think granting him a divorce today would make a difference?
Your Honor, so the parties, they would have this phone calls. My client thinks that he still has a chance to reconcile. And then so they would get into these conversations, and then it doesn't work out. And it centers around the marriage, salvaging the marriage. And my client believes that if they be declared divorced, even if you grant it for the wife, he would be okay with that. That would give him closure of some sort. I'm not saying that that would solve all the problems, but they would be limited to just communication via text, no more phone calls. Proof will show that wife initiates a lot of these phone calls. Not just my client, both of them are calling each other back and forth outside of the FaceTime that my client is allowed to have with a minor child. And so we're trying to just stop that cycle of both parties communicating between each other, and hopefully stop that unhealthy conversations. And my client is still working with the therapist. And so that's where he's at, Your Honor. We believe that he should be permitted to have unsupervised visitation at this point. There's no allegations of any unhealthy or unsafety conduct towards the child. Whenever mother left the home in May, from May to September, he did not see this child, even by phone call. When I stepped in, the only thing that mother would allow is a supervised visitation, and my client agreed to that. And so father was denied of seeing his child, talking to his child for about 4 or 5 months since May. And so when a mother tells you that I'm going to replace you as a father, I mean, you can only imagine how my client would feel about that. And so hence this recording that will be played. And so that's where we're at, Your Honor.
Let me hear from the guardian ad litem.
I think you need to listen to this recording. It was kind of disturbing. It certainly presents Mr. Gardner as a angry and perhaps violent man, and I think you need to hear it. Not only did that happen, there was another recording from just a few days ago, even after he knew that it had been recorded the first time. I think you need to hear them.
All right, Mr. Holly, if you want to put your client on the stand and let us authenticate your recordings, and then I'll allow you to play them.
Yes, sir.
Ms. Grammon, if you'll come forward, please, and ask you, if you will, to raise your right hand and be placed under oath.
You solemnly swear or affirm to tell the truth.
You may question her regarding the recordings.
Yes, sir. So, you're Miss Grammon, correct?
Yes,
And you have sent to me a couple of recordings.
yes.
Okay. So describe to the court how you came about getting this last recording that you sent to me. How did it come about that you and he were having even a conversation?
Well, we have to do FaceTime videos with Pearson. That is what was ordered by you the last time that we were here. Well, not the last time, but the time before. So during the FaceTime calls, he just starts talking to me, and I try to avoid it, but he starts asking questions about Pearson, and he just leads his way and into just talking. He knows how to manipulate me and how to push my buttons and just get me to talk.
All right. And this recording that you sent to me that was done a few days ago, I'll play that one first. You heard Ms. Smith testify, even after he knew it was being recorded that last time, he still made this recording with you, correct?
Yes.
All right. Judge, I'm ready to move.
All right, now, which, is this the most recent recording that I'm about to hear?
I was going to play the most recent one and then maybe do the other one if the court
All right.
wants to hear some more. This to me is again, as Ms. Smith said, he knows he's being recorded throughout this process. Whoops.
Why? Why did you have to do what you did?
Why do you make my life so horrible?
Tony, I wanted to work it out, and you had to go and record me and send it to Teresa out of context. Why do you make my life so horrible when I've made so many changes?
You haven't made any changes.
Oh, I have. I most certainly have. And the newest change is a deep-found hatred towards you.
That's always been there.
No, Tony, I loved you more than I loved myself. I always have loved you more than I loved myself. And now I despise you.
Yeah, I don't really care, Brian.
Why did you do that?
Why? Because you're threatening to kill me. You're threatening to control my life for the rest of my life.
I I never threatened to kill you.
Okay.
I told you that I wouldn't have a spouse in Pearson's life if you didn't
I
either.
don't care how you just keep rewording it.
Well, come on, say what you want to say to me.
I honestly have nothing to say.
When you sent the men to race, did you think things were completely over?
Yeah.
Yeah? You thought things were completely over, no chance of salvage.
Things have been completely over for a while, Brian. I was just
So
holding
in
on.
those 3 weeks, was there a chance of salvaging things between us?
What I told you was time will tell. And I wanted to believe that, I really did. But time is told, and honestly, it didn't take all that long.
Well, I'm going to get Pearson, whether you agree with it or not. That's what's going to happen. I'm going to try to prove myself to you, and I'm going to prove myself to everybody else, and I'm going to prove to everybody else that you're not this woman that you're trying to paint your picture to be, that you're not a great mother, that you're not a good spouse, that you're not a good person.
Okay.
I didn't want it to be this way. I didn't want to rip each other apart, but you made it adamant that all you care about is making me seem like a bad guy when I'm not. Bad husband? Yeah, absolute bad husband. Never a bad father.
You weren't a father at all.
Yeah, well, the only person who abused him was you.
I didn't abuse him.
You did.
I have never
Physically and
abused
verbally,
him.
it turns out. And you still do. You still put him in dangerous fucking situations like that fucking guitar
I do.
case.
That's so dangerous.
It is. If I put him in a fucking box like that, it would be the end of the fucking world.
I don't put him in a box. I don't care what you say,
In a fucking
Brian.
box like that, it'd be the end of the world. Because you're living it, it's okay.
I'm not putting him in a box. He's climbing into my guitar case and
And
gently
not
put.
to fucking move the case and not let him do it.
I do. And then he'll see it. And it is funny. It's funny that he
How
could fit in
put
there.
it in the fucking basement?
I'll put it in the basement for you, Brian. I will. I'll do it tonight.
You want to keep preaching that fucking God's going to keep you safe and God this and God that. Well, guess what? I've spoken with God. I've broken down on my knees and cried my fucking eyes out about this situation more times than I care to even say. And you know how hard it is to cry for me?
You can cry when you feel pity for yourself, Brian.
Oh, I feel pity for Pearson and myself.
Yeah, okay.
Because you're a horrible woman that won't let me be a father. And it's going to consume you when me and Pearson have an amazing life and you have nothing to do with it. I know it. So I'm going to ask you this, point blank period. Are you willing to stay without a man until he's an adult?
Brian,
I will
I'm
make
not
that deal
gonna.
person to person with you. And if not, I guarantee you as soon as we're divorced, I will go find a new wife.
Yeah, go ahead and, God, I feel really sorry for the next girl you're with, but I mean.
So you're going to try to bring a man into my son's life?
That's not in my plans, but You
I don't
can't
give a fuck
control
about what your
that.
plan is. I'm asking you to make a person-to-person deal with me.
I'm not making
I
a deal
will
with
bring any
you.
woman into his life.
I ain't making
and
a
he
deal
will
with
bring her
you.
into his life.
I ain't making a deal with you. That's just crazy. You're not in
How's that
control of,
crazy?
because you're not in control of my life.
I have way more control than you could ever imagine.
Oh, I know. Yeah, I understand that.
So what I'm asking you is to do the right thing and not bring a man into his life. And in return, I will not bring a woman into his life. I'm okay with not having any more children and not being married to anybody for at least the next 16 years, if you'll agree to it.
I'm not agreeing to anything. You're not going to take my life away from me.
Watch me.
You've already taken years away from me, and I'm going to have to work through things.
Don't you want to raise Pearson as his mother?
Yes.
And not have him calling somebody else mom?
I mean, that's his choice if he wants to call someone else mom, too. There's nothing I can do about that.
You're a horrible human being. Instead of just doing the logical thing and saying, you know what, that would hurt me. And saying, okay, if you can't...
I think it bothers you that it doesn't hurt me.
Huh?
I said, I think it bothers you that it doesn't hurt me. I think you want it to hurt
you
me.
really care about him if it doesn't hurt you.
I care about him more than I care about myself.
So do I trust him.
Yeah, okay.
Who I do not care about anymore is you.
That's great.
And you've made it apparent you didn't care about me first.
Mm-hmm.
What caused all this? All of this. Wasn't you leaving. Wasn't you cleaning out the house. It was you telling me I couldn't see him for Father's Day. That's what caused every last bit of this.
Yeah, I'm sure.
And you still didn't let me see him for Father's Day. Isn't that right?
Yeah, I mean, I don't... Sure. Yeah, that's
Isn't that right?
Yeah, that's right, baby.
Did I see him for Father's Day?
No, you didn't. Because we didn't have a parenting plan by then, I don't think. No, we didn't. We didn't have a legal plan in place yet.
We didn't need a legal plan in place for you to be
Yeah, we did.
to do the right thing.
The right thing. Marriages.
You're a horrible human being.
Yeah.
You deserve to suffer for the rest of your life over this.
Yeah,
You have cost me a quarter of my son's life so far that I have not been able to be there.
Okay.
Because of your own anger and emotions. When all I've ever asked for was to be a dad. That's it.
You weren't a freaking dad, man.
Pierce.
You're a single
You're a piece of
dude.
shit liar. You're a piece of shit liar is what you are.
Okay.
I provided for you and for him. Whether you agreed or not with the way I provided for y'all.
You provided for
And
yourself.
I continue to provide for y'all.
No, you don't.
Oh yeah, I do. I give you money every fucking month.
You haven't given me money in quite a while now.
3 weeks.
But,
3 weeks.
I mean, that's up to you.
Because I gave you how much last time?
$300, I think.
Okay. Which was what, $100 a week? And when I pay you again, it'll be $100 a fucking week.
I just don't care.
You do care. You do. Because if you didn't care, you wouldn't be being a piece of crap. All I want is to be a father, and you can't allow that.
I don't want to talk to you anymore. I'm tired. Bye.
Judge, that's all of that. There's another about 40, 45 seconds I could keep, you could keep listening to that, but there's no more discussion about it. Well, that was it. And that was a fair and accurate depiction of a conversation you have with Mr. Graham, is that correct?
Yes.
All right. And then the other one that Ms. Smith was talking about, I want to play this one, and again, at the end, I'll ask you if this is a fair and accurate depiction of what you and he talked about.
Hello. I'm tired of the back and forth. I can't physically do it anymore. Either we can be friends and we can be in Pearson's life together, or we can't. Either way, I'm going to be in his life. Yeah, I know. Okay. Duh. I'm not willing to watch you move on with anybody else, bring anybody else into my son's life. I'm
Way to increase the
stand
volume
by and
on
allow
that.
that to happen. I mean, what would you do about it? Like, I deserve to be happy if we don't work out. You've known from the beginning what to do about it, Tony. I mean, you always said if you ever thought I was cheating, that you would kill me. I mean, that's just crazy. Why would you kill me? And I've never cheated. I've never wanted to. And I don't even know if I want to be with someone else. I like being a wife, but, I'd much rather have peace than be a wife again. Divorce in God's eyes. You don't know God. Whether we get legally divorced or not, we're still married. God is a little more complicated. God stands. We'll still be together. You and I do not serve the same God, buddy. That has been made clear just by that statement. That's not correct. That's what? I said that's not correct. I disagree, and I hope that that's just a tactic of control. I think that's in everybody's best interest that we try to work it out. Is it really? Because it's not in everybody's best interest. I think so. I think it's the only way Pearson gets to have two parents. So I don't know about that. I'm sure you would move on. You're just trying to control me. My mind is made up. My mind has been made up since before we separated, or when we separated. My mind's been made up. And sure. In my eyes, there is no such thing as divorce under God. But that is correct when you say that is in your own eyes, because that is not what God says. That is not. I've seen how this is going to go. Yeah, he says that divorce is done and acceptable when there's been infidelity. So, and abuse. The judge and abuse. Divorce or not. No, and abuse. You have to show me the scripture that says that. Oh, I will. I'll find it because I have read it before. All right. Well, me and a bunch of people have looked for it. Oh, a bunch of people? That's just so cute, Brian. That's so cute. And you know what? God is a lot more mysterious than you think. All right. Well, you know He has good for me and for Pearson. You know who I am. I disagree with you. You know who I am. You want to go through with this? So be it. But you're going to make my life hell, is what you're saying. That's not what I said. My opinion from the beginning, Tony. You've known my life. You cannot control me. No, I didn't. No. What? You can't control everything about me, Brian. If we ever separate, you can't just dictate me anymore. You're right. So if you want to go and try to have another baby or be with another man, that's your choice. I'm going to respond how I need to respond. And you've known from before we got married what my response to cheating is. So I love you, and I'm not going to watch you have sex with another man or bring another man into my son's life. You don't want to talk to me, you don't want to try to build things with me, that's your right.
That's your right. I will fight with the court for my time with my child. I just wish the gravity of things wasn't quite what it was. So, fine, I'm bad for you. That's how you, honest to God, feel. That's what's in your heart, that we cannot make things work no matter what I do. That's your right. But I have my own rights, my own opinions. And I have my own solutions. So, I love you. You can never say I didn't love you. Whether I portrayed that or not, I loved you. I hate that this is what things have come to, but it's where we're at. So, there's nothing I can do about it. You're right, I can't control you and I can't make the decisions for you. You do what you want to do. Hello?
Yeah.
I wanted things to work between us, and I have put my best foot forward in that, and I will continue to put my best foot forward for Pearson. And you're right, you don't trust me. And frankly, I don't quite trust you either. So, maybe you're right in the grand scheme of things. Maybe it's just not meant to be. I thought it was what was best for me, you, and Pearson. I still think it's what's best for me and Pearson. But if you're going to threaten me with, you think you deserve to be happy, you deserve to be a wife, try me. I love you, and I'm not just going to move on and, okay, my wife's having sex with somebody else and be alright about it. Okay, my wife's trying to have a baby with somebody else. Okay, my wife's got some other man in my son's life. So, go ahead, record it, do whatever you want to do with that information. I'm sure you've been recording me the whole time anyway.
No.
I didn't know you were recording me when we were together, so.
Yeah, well, nobody would have believed me.
Well, you know what it boils down to, and that's all I'm going to say about it. If I can't be with you, and we can't be together, and we can't be a family like God intended, go ahead and try to move on. Go ahead and bring somebody else in my son's life. It ain't gonna last long. I wanted to be your one and only. I wanted to be your first and your last. And I still want to.
You want some more cheese?
I want some more pepperonis.
You want some more pepperonis and cheese? Okay. Hey, careful. Give me my remotes. Thank you. Thanks, bud.
So as far as I see it, there's two options. Either we both we get this divorce and we both stay single for the next 16 years till he's an adult, or we work it out. Because option 3 is horrific.
Okay, well, I'm gonna get off the phone with you because I got more stuff to do tonight.
I know, it doesn't mean anything to you. My level of care has no bearing on anything, so is that what you're telling me?
I'm telling you, I don't want to talk to you anymore. You're freaking me out.
So you just want to fight it out in court?
I mean, I think it's really funny that you've been all, I love you and I'd do anything for you, and you flip on a dime.
No, I do love you and I would do anything for you.
Bipolar.
I do. The only thing I'm not willing to do is like watch you move on with another man. Because affecting my son in that situation. Just like I'm sure you wouldn't want me to move some bimbo in with me and have Pearson start calling her mommy. I guarantee you that will destroy you. For you to not see it from my perspective.
That's because you make it with a bimbo.
Okay. Tony, you've known what it is from the beginning. Do what you want to do, but keep that in mind. If you are telling me leave you alone 110%, you don't want to interact with me ever again, that's your right, and I'll respect it. And I will fight you tooth and nail in court about Pearson. But keep in mind, I have told you the situation from before we got married.
Brian, you're making me want to vomit. So I'm going to get off of the phone.
I'm making you want to what?
Vomit, to throw up, spew. And I don't want to talk to you anymore.
That's fine. And I'm okay with that. We both know how things lie. If you don't love me and that's where your honest heart is, I won't call you no more. I won't interact with you at all anymore. That's what you want?
I just want to get off the phone with you right now. Because you're scaring me.
Good luck with things, Tony.
Mr. Grammond, is that a fair and accurate depiction of a conversation you had with Mr. Grammond? And that took place after our last court hearing, is that correct?
Yes.
When he says that was he has a response to cheating, he has my own solutions, we can't be together, it ain't gonna last long. How did you take those comments by him?
Well, they're threats. He's threatening to kill me. And like I said in the recording, it's not in my plans to move on to another man.
Pardon?
Objection.
To what?
Speculation. She's saying that he was threatening him. There was no direct threat there. So at this point, she's speculating.
Overruled, she's entitled to interpret, and this all goes to the statements that were made during the conversation and what impact they had upon her. It requires her to interpret what he's saying and to determine in her own mind, does it require some speculation? Sure, but it also goes to how those statements, what impact they had on her. So overrule the objection.
Describe to the court how fearful you are of being in proximity with him.
Every day, I can't even describe how I feel. I just live in terror.
Are you familiar that he's changed locations from the last court hearing?
Yes.
And where does he live now?
The KOA campsite.
Is that a fair and accurate depiction of the picture that we received in discovery from he and his lawyer?
As far as I know, yes.
Yeah. And as far as you know, he's living in a camper at the KOA now instead of at that other place?
Yes.
Okay. What are you asking the judge to do today as far as how to interact with Mr. Grammond in the situation with visitation?
Well, I personally would not like to have to interact with him anymore because, well, that door was open because of FaceTimes with Pearson. I don't trust Brian and Pearson being alone together at all. There's been supervised visitations. They've been going okay. I guess just keep it at that. I really don't know what else to do with that.
And you do have a second meeting appointment with Dr. Berryman then tomorrow, correct?
Yes, I do.
And she hasn't given you any time frame as to when this is going to end, has she?
No, she is not.
That's all I had to.
Mrs. Grammond, when was that, the second recording, the longer one, when was that taken? Do you know?
I don't know the exact date.
Isn't it true that that's part of a longer conversation?
But yes, it's part from, yes.
It was part of a longer conversation, but you left out that part when you told him that he's not able to fulfill the role of a father. You told him that, correct?
What did I tell him? Can you
That he
repeat
was
that?
not able to fulfill the role of a father. Did you tell him that? Yes or no?
No,
You didn't tell him that. Okay. You didn't tell him that any man would be better.
no, because
Okay.
I'm not with another man. I really don't want to be
Okay,
with
but
another
you
man.
testify that, yes or no? You testify that that was a part of a longer conversation. So we don't know the context of this recording because you did not provide the court the whole conversation. Is that correct?
That is all that
Yes
I have
or no,
recorded.
ma'am? Yes or no, ma'am? Is that correct? You did not
Mr.
provide.
Hawley, hold on a second, Ms. Henderson, Mr. Hawley.
Judge, I'd object. We're going to argue that she should be allowed to, even if it is a yes or no answer, explain the answer to her question.
Judge, I'm simply asking if this was part of a conversation.
Sustain the objection, allow her to answer the question, but first you must answer yes or no. In other words, if it was part of a longer conversation, whatever she asks you, if it's a yes or no answer, answer yes or no, and then you will be allowed to explain.
Okay. Can you repeat it?
I'm moving on. Now, you said you were fearful. You never called the police, yes or no?
No, I have not.
You did not take any order protection against your husband.
No, but I would like one.
And you would, in the past weeks here, after we were here for that 2.5 days of hearing, you were calling him, is that right?
Yes, for FaceTime videos.
Even just for FaceTime videos?
No, there were also other times where we would call.
Where you would facilitate the call, is that right?
Yes.
I have all the recordings here. Do you want me to go over with them with you? All your phone calls where you initiated the call, you want me to go over them?
Whatever
with
you'd like
you?
to do.
Okay, so November the 25th, this is an incoming call and you talked for 50 minutes. Do you recall that?
I guess.
You initiated that,
Yes.
obviously.
Mm-hmm.
And you have another one here the following day, 2 hours and 12 minutes, correct?
Yes.
Now, I can't remember did you give me the date of that recording, that second recording that was the longer recording?
I do believe so. I think they've both been dated. I just can't remember off the top of my head.
Was it in November? Was it in December?
Which one?
The longer recording, the second one that was played,
That was the first,
the 10-minute conversation.
November? I don't know. It was either November or December. They're very close in proximity.
Okay, after that, you still proceeded to make phone calls, conversation with him, is that right?
I know I called him once about insurance.
Okay.
But we've been having to do the FaceTime videos.
You had a conversation with him in December even. I have one here for 20 minutes. And that was after you alleged that you were very fearful, is that right?
I am fearful, yes.
Okay. You could have just hung up on him, but you stayed in the phone call, is that right?
No, because he would call you and say she's taken away time from my child.
But you were talking to him. You were not allowing him to just talk to the child. You were welcoming the conversation, correct?
Yes, because
You were
he
responding
kept
to
claiming that I have changed in the goodness out of my heart, wanted to believe that. And I wanted to give him another chance if there was any decency left in him. And he just proved, he puts on many masks.
How are you giving him another chance when you tell him he could never fulfill the role of a father? Is that giving another chance?
I didn't say that.
Okay.
Because he needed
it
to
was
prove
never
to me
not an
that he's a
indication there,
changed
ma'am.
man.
I'm gonna ask the question, so just let me finish the question.
Judge, if I may, she was trying to answer the question.
There was no question there, Your Honor.
Well, she was, I think, supplementing her answer, but let's wait for a question to be asked. If your lawyer can bring out anything else, if on the redirect.
I'm sorry.
Is there any indication there that he was forcing you to answer his questions there?
very persuasive, and he knows how to get into my mind.
But you could have just hang up, right?
He would keep calling.
Or you could just not take the call, correct?
I guess that would be nice, but
But you love these kinds of conversation, is that right?
I love what?
Because you can get out of him these kinds of recording.
No. He hurts my mind every time he speaks.
Ma'am, I don't
with
have
me.
a question yet.
Okay.
You told him you are not a father. Is that correct? Did
No,
you
I
hear
didn't.
that?
No, I didn't
You
say
see,
he's
we
not a
can play
father.
it again, ma'am. You said it. I wrote it down. You said
Okay.
you are not a father.
That he was not acting like a father when we were together. He spent like no time
Ma'am,
with
your
Pearson.
words were you
Mhm.
are
Ms.
not a
Hendrickson, let her
father.
let her finish her answer before you start asking the next
Can I
question.
just rephrase, Your Honor? I'll just withdraw that. How would you feel if he tells you you are not a mother?
He does tell me that. He's told me worse things than that on a daily basis when we were together.
So do you believe that you need a parenting plan to allow Mr. Graham to have a Father's Day visitation with Pearson?
Yes, because we didn't have one set yet. We were still in the works.
I know
with
that. I'm just
everything.
asking, you believe that you need to have a parenting plan in order for you to allow or to give him some time on Father's Day? That's your position.
Yes, because he was not safe whenever we left. We left out of a dangerous situation with him.
You left, he handed you your gun on the day that you left, correct?
One of them.
But he did.
I'm gonna object to this. This is all stuff that you heard before we had that last hearing. We went round and round. We went 3 days arguing about this stuff, and this was all before that last hearing. I thought today were for the review, see how things have been going.
But I'm entitled, Your Honor, to rebut her statement that goes to her credibility. In our last hearing, she confirmed that my client handed her gun on the day that she left, and now she's saying she was living in fear on that day. So I feel like I'm entitled to that.
You said that he gave her one of the guns.
Yes,
Is her answer.
one of her guns, yes.
Okay. Question's been asked and answered. I don't know that it has a lot of relevance to the issue today, but it does seem like we're re-plowing the same ground we've been over before. Move along.
Yes, Your Honor. You lied to him when he asked you if you were recording him, correct?
He asked me, have you been recording
You
the
need to
whole
answer the
time?
question. This is an example. She asked you,
Okay.
did you lie to him? So your answer would be yes or no, and then you can explain it.
Not exactly, because
Okay.
of how he worded it, no.
He asked you if you were recording him, and you said no.
He
You
asked me
recall
if
that?
I was recording the whole time, and I said no.
Okay.
I was not recording the whole time.
And he told you at the very end, he said, I'm not going to interact with you anymore. You recall that?
Yes, but he still does.
Have you been to that COA where he is now residing?
Anyway, no.
Previously, you've never been to that
No,
place?
No, I could see it from the interstate, but I have not entered into it, no.
And did you know that families live there with children?
I'm sure some do, yes.
It's a standard place where people put their camper in as long as it's livable.
Yes,
Did
anybody
you know
can do
that?
that, yes.
Nothing further.
Ms. Smith, do you have questions?
I'm a little confused. Were the recordings made after the FaceTime visit with Pearson?
These are during the FaceTime visits.
They were during the FaceTime visit.
Yes.
So Pearson was present. Well, you could hear him.
Yeah.
And I mean, had he talked with Pearson beforehand?
Yes, but he would always try to get me to start talking with him and lead it into just talking with me. He even asked Pearson about me instead of just talking to Pearson.
So did Pearson hear these conversations?
I'm sure he did. I mean, as much as a 2-year-old is going to listen, but he's watching TV and playing. And
I have no more questions.
Redirect?
Ms. Henderson asked you about order of protection. You asked me to inquire about it. You inquired with me about an order of protection based on this, didn't you?
yes, I did.
What was my response?
I didn't get a response from you.
And again, these were during the FaceTime videos. You can hear Pearson. Is that the child in the background? Is that Pearson?
Yes, and the TV also.
And Mr. Grammond could hang up on you as well, correct?
Yes, he
Ms.
can.
Henderson said, why didn't you hang up? But there was nothing forcing him to stay on the phone either, was it?
Mm-mm.
And she asked you about the KOA campground. Have you looked at what concerns do you have about the KOA campground?
Well, just about anybody can go into those places like pedophiles. What's going to stop a pedophile from parking a camper there? That's kind of you never know who your neighbors are, and they're constantly changing.
Has that concerns you enough to look that up?
Yeah, I mean, I don't really know how to. It's just a great fear of mine.
That's all I have.
Very short. Did you know that they do background checks before you can even be eligible to live there in that campground?
Yes, I do.
And so, according to you, it's an unsafe place to live, even though you got many children living there, correct?
It can't be, yes.
That's all.
Any other questions? Thank you, Ms. Grammond. You may have a seat.
Thank you.
Mr. Hawley, do you have any other proof?
I do not, Judge.
Ms. Hendrickson, do you have any proof you wish to offer?
Yes, Your Honor, I would like to call my client.
Mr. Grammond, if you'll come up, please. Grammond, if you want to have a seat, well, that's fine. You're fine where you are. Mr. Grammond, come up. Raise your right hand and be placed under oath.
You solemnly swear or affirm to tell the truth, whole truth, nothing but the truth, so help you God.
Swear.
Mr. Grammond, the first recording that was the shorter version, how did that come about? Do you recall when that was?
We were talking pretty frequently at the time. It was prior to a visit with my son. I believe I was actually driving to the visit with Pearson. Things were going pretty well between us at the time, and then out of nowhere, she decided to tell me how I've never been nothing but a baby daddy to Pearson. I've never been a husband to her. That'd be the easiest thing in the world to find a new man to raise him as a father, because I'd never fulfilled that role, that anybody possible would be better than me. Anybody could provide better for them than I could.
How did that make you feel?
Angry and upset. I've modified my entire life over and over again to try to show that I can do whatever I need to do for Pearson, whether it was moving to the cabin and then concerns being raised about that, to moving into the camper and moving closer to Pearson, to concerns being raised about that now.
Did you go through a background check before you were eligible to live there in that KOA?
Yes, I did. Everybody in the long-term section of the campground has to undergo background checks.
Okay. That first recording, who initiated that call? Do you remember?
It could have been either one of us. There was probably a few hours of conversation that day. That exact call, I'm not sure who the initiator was.
Okay. That second phone call, the longer version, the 10 minutes, do you know who initiated that call?
I believe it would have been Tony. It was after a conversation with my son, where she ended up taking the phone from him and interacting with me, and once again trying to push some buttons, which we don't get to hear, to get a rise out of me, and I fed right into it.
After those 2 phone calls, did you have any more phone call conversations with her outside of the FaceTime?
She's made a couple attempts to interact with me. One while I was talking to Pearson, which I responded directly with a text message to her. I hung up the phone and told her, do not try to interact with me when I'm interacting with my son. This is me and his time. There's nothing for me and you to talk about anymore. That second phone call, I kind of seen as closure for myself as far as me and her go. And then the next morning, I believe after I sent that text to her, she reached out to me early in the mid-morning, wanting to talk to me. And I told her that we are not talking under no circumstance. There's nothing to talk about anymore. And she tried to turn it into, well, I also have a question about insurance. I sent her a copy of the iInsurance phone number, and that was it. I ended the phone call.
Okay.
It lasted about a minute before I hung up.
Now, do you recall when we were last here, we basically agreed that the communications will be just via text message between you and her? But even then, you both were calling each other. Is that correct?
Yes, less than before that was put into place, but
Who was initiating the phone calls more than the other?
she would have been initiating the majority of the phone calls.
Okay. Now you understand, and you heard me earlier, we were requesting the judge to basically pronounce you divorced if you all agree that there are grounds here. You understand that both of you are free to see each other, correct?
Can you read?
I'm sorry, both of you at that point, y'all can do whatever y'all want, but are you conceding that this marriage is over, it's
I
done?
don't want to object to the leading and the relevance. We're not in a position to talk about divorce today.
Dane?
Your home in KOA, is it suitable for your child?
Most certainly. When I moved into the camper, it was something that I talked with Tony previously about. Tony has seen videos from being on FaceTime with me and me showing her Pearson's room and has agreed that she likes it. She has raised concerns about the people that could be around, but I've gone through a background check. I'm making the best choices I can. I had the cabin on the lake, and that was a problem. Now this is a problem. Like, I'm running out of options here.
Okay. Is it more economical as far as living situation for you?
Yeah, it's kind of one of the only options left with how bad my credit has become. Any apartment I've tried to get into, they want to run a credit check, and I fail every one of those. So, this was the most stable place I could be besides the lake, and I left the lake solely because issues were raised, and I was trying to bring her some comfort in the fact that if that's such a problem, I can try to do something different.
How are the visits going now with Pearson?
Not frequent enough, but they go very well. I know we both look forward to him all week long. He's constantly telling me on the video chats or in person that he misses me and he loves me, and it's hard not seeing him as much as I feel like I should be seeing him. But the visits are great up until the last few minutes when it's time to go. And it's time to start cleaning up, and then you see a whole different side of him because he doesn't want it to be over.
Are you asking the judge to allow you to have some sort of unsupervised visitation at this point?
Yeah, I mean, that would be ideal. I mean, as it stands right now, I feel like I don't get time to be a father. I get to change him. I get to feed him when I'm on visits, but I mean, I don't get to put him down for a nap. I don't get to put him to bed at the end of the night. Like, I'm not necessarily getting to be a father as much as I'm getting to be a playmate.
And you're still continuing to see your therapist, is that correct?
Yeah, there was a period of time with switching job sites and being farther away during the workday that I had stopped seeing Janet Weismark. But after the final interactions with Tony, I decided that there's definitely some more things to work through. So
And are you still providing financial support?
to the best of my ability currently, with moving and everything and terminating the other lease. I mean, it was quite a financial burden, but I thought it was what I had to do to show everybody that, like, well, if this is a problem, I can do something differently.
And then when is your next appointment with Dr. Berryman?
Tomorrow, and my next appointment with Weismark is next Wednesday.
That's all, Your Honor.
Yes, sir. Mr. Graham, you failed your drug test, the nail follicle, nail bed test for cannabis. You remember that?
I do.
And you have a 1.28 was what you had as far as your screening goes. Do you remember that?
In a toenail test, yes.
Yeah, and the cutoff was a 0.05 that was listed on the test. Did you see that?
I don't have the test in front of me, but from what I recall, it's a 0.99.
So where was the 0.99 on that test? Do you remember where it was on that sheet at all?
Next to the number 1.28.
All right, so if the judge is looking at it and it says 0.99 and 0.05, whatever that says, that's what it would be, correct?
Yeah, I remember that pretty well.
And if it says 0.05, can we agree that that's a long way away from 1.28?
I would disagree with that.
Are you vaping at the church during your visitations?
No.
So if mom comes in here and says she's seen that, she's not being truthful.
She would be lying.
All right. You knew you were being recorded when you were saying these things to her? Was that what I gathered from your direct with your lawyer?
I didn't know. I assumed.
You said that you were like in a long-term KOA?
Yeah, I'm in the long-term section.
How big a lease did you sign?
Till 11/25 of 24.
And then short-term, where are those folks at?
At the entrance.
Okay, so what are you about? How far away are you from the short-term people?
Couple thousand feet.
Okay. And you said that you had failed a credit check?
When I was applying new apartments priorly, yes, I'd failed credit checks.
You make good money, correct?
I make okay money.
How much was your annual that we calculated on your child support? 50, 60, somewhere in that ballpark?
Probably in the high 40s, 50s. I'm not exactly sure.
When's the last time you paid child support?
A couple days ago, I sent Tony money.
How much did you send her?
I'm not sure. I think $225.
Before that, when did you send her any child support?
About 3 weeks before that.
And how much did you send her there?
I think $300.
Okay, and you see what your obligation is in this order, correct?
As of a couple days ago.
Nothing further.
Now, I noticed from the conversations, the recorded conversations, you had some pretty strong language for your wife. When you despise her, she's a horrible woman. She'll suffer for the rest of her life. She's a piece of shit. You did, correct?
Yes, I used some strong language.
And you used some curse words too, correct? Like you said, fuck.
Yeah, that is correct.
And your child was present, correct?
In the recording, you can hear my child come in to the room from the other room. And in a phone conversation, I mean, if it's going that way, it ought to not be on speakerphone, which I would assume it wasn't. He shouldn't have been able to overhear any of that. And you also do not hear what was said to me prior to that.
You, can you understand why your wife might be afraid of you?
In a way, I can see why she wouldn't want to be around me. I don't want to be around her likewise. Although if somebody's truly afraid of you, I don't think they would intentionally seek a rise out of that person.
I have no more questions.
You said a couple of things in your recording that I want to ask you about. One of them is that you made reference to something about the situation before we got married. You remember saying that?
I did.
What were you talking about there?
Well, when we got married, before we got married, we sat down and we had some pretty lengthy conversations about how things would go if they hit their worst, which is pretty much where we're at now. And we had agreed that if things did ever go wrong after we had a child, that we would not be malicious in taking care of that child towards the other person. We would not try to take the child away from the other person, that we wouldn't make our problems for the child.
All right. And then the second thing is that you told her that basically the way things would go in the future was that you two could stay together or you could both stay single for the next 15 years. I assume that had to do with your child until the child turned 18.
That is correct.
You're not going to allow another man in your child's life. Is that what you're saying?
I'm sorry.
In the recording, you said that you and your wife would either stay together or that you would be single and apart, but neither of you could stay unmarried, in other words, for until 15 years until your child turned 18.
That was the arrangement we had before we got married, if things ever went bad after having children.
And so you were basically telling her that, if I understood you, that you were not going to allow another man to come into your child's life.
It would be against my wishes. I mean, in the end of the day, she can do whatever she wants to do, but I mean, I'm not saying I wouldn't share with that person all the chaos and the hell that she'd put me and Pearson through and try to get that person to walk away from her.
You understand that you no longer are going to control anything about her from this point forward.
I'm aware of that.
And while you will have input regarding your son, that you're not going to be able to tell her what she can and can't do, period. Whatever your relationship has been while you two were together, then you're not going to be able to do that. You can't control her, you can't threaten her, you can't do any of those things. You understand that?
I'm aware.
All right, step down. We'll stand at recess for about 5 minutes.
All rise.
All right. Mr. Holly, do you have any other proof? Senator, any other proof? Ms. Smith, do you have any witnesses you wish to call? I'll be glad to hear you in argument. Mr. Holly will go first.
Judge, well, the tapes speak for themselves. That's why I brought them. This is a scary situation. I mean, you listen to those tapes, to me, there's a level of concern here, and that's why I wanted you to hear these tapes. He failed his drug test. When he said it here before and said he didn't do marijuana, he would pass it, and he welcomed the drug test. I went back and listened to what he said. The supervisors or nerds in, when they're doing this supervision, we're requesting that at the very least, other than just, hey, we're here, this is the time, keep the discussion at a absolute only about what we're doing as far as times and the kid, that kind of thing.
Conversations with who?
Her mother, Mr. Grumman and her mother, or the pastor, or whoever is supervising with the child, asked that there be no vaping during the visitations. And, again, that the parties will get it in the order, communicate about the child and the visitations and, leave the other dialogue off. I think that's the best thing we could do at this point. The KOA campground, always a scary place to go do visitations. The court's well aware of that. I don't have to get into all of this. It's not an appropriate place for a child to be, for any length of time. So we're just asking maybe for the status quo to continue. Let's get Dr. Berryman's stuff back and see what she says. I'd like to have permission to send Dr. Berryman these tapes and whatnot for her consideration as well. Thank you, Judge.
Hendrickson?
Your Honor, there was no proof about the vaping situation, and so I don't know where that's coming from. Again, my client testified that he did use marijuana and he put a date on it. It was May of this year. And so that was to be expected that he would have negligible positive result, which he followed with a hair follicle test that proved to be negative. The KOA, there are children who live there with their families. Just because that's the only thing they can afford doesn't mean that a parent cannot have visitations there with their children. Again, we are asking that it doesn't look like mother is stipulating to there are grounds for divorce, but we are asking, Your Honor, if you would just grant her the divorce and find my client at fault. My client is fine with that. Declare them to be divorced. That would alleviate some of these discussions. My client will not enter into those discussions anymore. He is wanting to abide by just text only between them, no more phone calls. And so at this point, we are asking for unsupervised visitations, however graduated they may be. I understand that my client has not been with the child for a longer period of time, so it would need to be a gradual situation. Thank you, Your Honor.
Before Ms. Smith gets up here, Mr. Hollis, she's asking for me to grant your client a divorce.
I'm not in a position to agree to that.
You're not in a position of what?
I'm not in a position to agree to that with her at this point, Judge. We haven't discussed it, and
She doesn't want a divorce then?
well, we filed for divorce, and we have filed for divorce. So obviously we're going down that track. So,
and she wants a divorce or doesn't want a divorce?
At some point, we're going to get a divorce, I would assume, Judge, but we're not in a position to agree to a divorce today.
I'm not sure I understand the logic of that, but what it is. Ms. Smith?
Again, Judge, before wants to take a break, I can go outside and talk to her, but I haven't even discussed it with her. And I'm having to wear a mask today to talk about all of these things, and I just need some time.
Ms. Smith?
Well, at this point, I would oppose unsupervised visits. The cursing, calling his wife names, I think until we get Dr. Berryman's report, and he says he's seeing Ms. Wisemark. We probably need a report from her. He is angry, violent, and I would be afraid of the things he would say to the child if he was unsupervised. If he says these things knowing people are listening, what would he say to this child if he had him alone without anyone supervising the visits? One of the things I noticed is the difference in the recordings on the part of wife. I mean, the first recording, she kind of has some spunk. The second one, she was pretty beat down. I would not like to see that happen to Pearson.
This is here for a review and a review of the situation. Previously, the court heard recordings involving these parties, and that caused this court to have some concerns. And having observed the parties during their testimony today, I basically find that those concerns that I had at the original hearing have simply been confirmed and reaffirmed today. The recordings today that I heard during the hearing clearly affirmed that Mr. Graman is an individual who believes that he should be in control of the situation. He believes that he should be the one to call the shots, and he tries to manipulate the situation so that he can control his wife. And he does so by threatening her with a lot of different things. That will stop today, because from this point forward, there will be no direct communication between them whatsoever. But I'm putting you under an order as well, Ms. Graman. He says you've called him, and you can't have it both ways. If you don't want to have contact with him and you want to be apart from him and you want to be divorced from him, albeit I could grant you a divorce today, but so be it. I will leave you married, but you are not going to be allowed to have direct contact. You can't pick up the phone and call him. You have a question, if it's about insurance or whatever, you call your lawyer, and he can call his lawyer, and they can work it out. But the reason I'm doing that is because he says you initiated and then you push his buttons. I didn't hear any buttons being pushed, but apparently his buttons are fairly large and easy to reach. So as a result of that, we're not going to have you call him for any reason. But he's not going to be allowed to have direct communication with you at all. I considered, Mr. Graman, completely doing away with these FaceTime videos after listening to those recordings, because it's just an opportunity for you to try to engage her in an argument or whatever. And you may say, you may have all sorts of excuses, and I realize that you try to present yourself in a different light when you're here in court. But when this last interchange that you and I had, basically, and I asked you about the idea that you thought your options for you and your wife were to either stay together or stay single for the next 15 years, and whether or not you were going to be okay with her seeing someone else. Basically, if I understood you to say that you were going to make sure that if she did date somebody, that he knew what he was getting into, and that you were going to try to convince him, to stay away from her. And that is not going to happen. I'm just telling you, you have lost the control over your wife, period. And whether or not you have contact with your son, your child, will depend on how you behave and how you conduct yourself from this point forward. I am not going to alter the supervised visitation schedule that we presently have in place until I see Dr. Berryman's report. I ordered a psychological evaluation of both of these parties because of the issues that I saw and the concerns that I had. Those have simply been strengthened. And as a result of what I heard today, I have even more concerns about whether Mr. Graman is going to be able to follow a court order regarding a visitation and custody of this child without creating havoc in both his ex-wife or soon-to-be ex-wife and the child's lives. So I want to see what the psychological report is. And yes, those recordings that were played today and the original recordings need to be sent to Dr. Berryman, and if necessary, they need to come from the guardian ad litem so that the guardian ad litem can be the one to supply that information. Both sides can then explain to Dr. Berryman what they take from that. If that's what they choose, it'll be up to her to do that. But until we have a psychological evaluation report from Dr. Berryman or whoever she might send for any sort of testing, it is my opinion there should be no changes, with the exception of the fact that during the supervised visitation, Mr. Graman will speak to the people when he comes in, and he will not speak to them beyond that. He will spend his time talking to his child, not seating with the people who are there for the visitation. He can have a conversation regarding any issues, if the child's eaten, all of those normal conversations, but he cannot go beyond that and have a conversation about eating issues in this case. He will be allowed to continue the FaceTime calls, but when he does, you put the child in front of the camera and you walk away. And if the child stays there, that's fine. If the child doesn't stay there, then you're not obligated to round the child up, because that simply gives another opportunity for him to do it. Talk to your child, explain to the child this is a visit with dad, and encourage the child to stay there, and then you walk away. Doesn't mean you have to leave the room, but you have to walk away. You don't stand there and engage with him. There's not going to be any more of this. Any FaceTime can be recorded by either party. If you wish to do so, you can record it so that either video recorded or audio recorded, so that for your protection about what's being said and what's being done. That's the same thing with Mr. Granman. He can record anything that he wants to do. Court has some concerns about where he's living in the KOA campground. I'm familiar with it. Not sure that that's a logical place to take a 2-year-old child, but I'm open to being shown more proof about that at a later hearing when we get to that point. I want to make it clear that under the law, I don't care what your agreement was when you and she got married, Mr. Gramman, under the laws of the state of Tennessee that I'm required to enforce, this matter is now before this court and under the jurisdiction of me and the other judges that hear these cases. And as a result of that, we're going to be the ones who have to make those decisions. So I want you to see your son. I want this to move quickly and productively towards you having, a good visitation, an open and unsupervised visitation. But it requires you both to cooperate. And that means you leave her alone. You don't threaten her. You don't have anything to do with that. And I want this order to reflect that there will be no threats. And I've already said that neither party will intimidate, threaten, or be violent towards the other party. But I want to include in this new order that neither party will harass or argue with the other party as well. Let's just try to cut all of that out. And then we'll see where we are after we get Dr. Berryman's report. In the meantime, everything remains the same. He has a child support order that's down according to this order that was entered and signed by me today from the prior hearing. We'll see how that goes. And it's my hope that perhaps there'll be some changes made in the behavior of both of these parties by isolating them from each other. But you can't call him and initiate a conversation. You can't call her, Mr. Gramman, and initiate a conversation. We're going to cut you off from each other and allow you to instead just focus on your son and allow you to have that contact. That FaceTime will continue, the visitation will continue. I'm not stopping that, but I want to make it about the child and not about what's going on between the two of you. That's the judgment of the court in this case. Thank you.
Since the holiday's coming up, is there any way that you would include some type of?
He needs to see the child on Christmas Day. I don't know what you two can arrange, but I want to see, you can step out in the hall, the lawyers can, and see if you can arrange to have a visitation worked out for sometime during the Christmas holidays.
And then the second thing, Your Honor, is the current visitation is twice a week, Tuesday and Saturday. We would like to ask if you can add another day, even if it's every other week.
I just said I'm not changing anything. So.
Thank you, Your Honor.
All right.
Thank you, Judge. I'll draft the order and send it to Ms. Hendrickson.